morning, everyone. This is the fourth meeting of the State Bar Stakeholders Working Group studying the Legal Services Trust Fund Commission and the IOLTA program. I welcome you all to our fourth meeting. As we get started, we'll now have
has joined the conference.
Take attendance and a roll call. Thank you.
Chavez Peterson, Copeland, Estrada.
This is Margie Estrada. I'm participating today as a public person.
Okay.
Member of the public.
Fortescue. Friedman.
Present.
Gershenson.
I'm here.
Hammond. Manning.
Here.
Maria Jimenez.
Here.
Martinez.
Here.
Morrow.
Here.
Justice Ray. Reines.
Here.
Schreiber.
Here.
Seleg. Board member. Okay. Judge Seligman. All right.
Are there any members of the public who would like to come forward? And
Carmen Chavez, Casa Cornelia Law Center.
Has joined the conference.
As a matter of procedure this morning, I would like to recommend the members of the public who have a presentation to make come forward now and do so. If, on the other hand, you would prefer to reserve comment for a later point in the presentation, please let us know now so that we can better prepare for it. There will be a public comment made at 1 p.m. due to a scheduling conflict by a member of the public, so we will have comments other than this morning. If there are members of the public, please come forward, identify yourself.
Good morning, Catherine Blakemore, Disability Rights California. Thank you to all of you for being here and continuing to be generous with your time as we work through some interesting issues. First, I want to express appreciation for the thoughtfulness of your approach with the IOLTA formula and what I understand to be a decision to postpone any statutory changes until such time as the Justice Gap study is done. That has always made sense to me, as I think we'll have significantly more data and I think enable us to think more comprehensively about what the right solutions are if a solution is needed. I did want to speak just briefly to Reboot, which is
has joined the conference.
Your agenda this morning. I speak of it as a process that took a great deal of time and investment of numbers of people, both trust fund commission members, legal aid programs representatives, and state bar staff. But it also has been an extraordinarily collaborative process, and over the length of time that Reboot has been in existence, I think we have made some very good decisions about both how to streamline the processes that are used with applications and so forth, and found new ways to measure what legal aid programs are doing, which I think provides for all of you, to the extent you're able to look at that data, more complete information about what legal aid is doing. So for the first time, we're, as a statewide system, measuring what are the main benefits that individuals who get assistance from us receive. What are the economic benefits? So essentially a return on investment of the work that legal aid programs have done. And we're continuing to work through and refine those so that we can ensure consistency of data throughout the state. But to me, those are really valuable ways to show the impact of legal aid that until such time we haven't been able to do on a statewide basis. Other things we have done and recommended are ways to report our systemic work to the bar, and the bar has accordingly adjusted the kinds of reporting that we do so that in addition to the CSR data, which has been the subject of a lot of your conversations, we now report in a more comprehensive way the the work that we do on systemic work and demonstrate sort of the impact of that work. All of those are all designed to give a more complete picture of the work that the legal aid programs in California do. My last comment is there's also on the agenda, it looks like, are there ways to further streamline with a look towards future improvements? I have spoken previously about the evaluation of legal aid programs. I am a fan of evaluation of legal aid programs. I think sometimes there's ways that can be done more effectively. I received 9 different federal grants. We're a federally funded legal aid program, but not from one source. So there's 9 different federal agencies that fund us. So they all come out and do reviews of our work. And the process that they've begun to go through is to look at the program and the written reports that we provide, and then sometimes do a phone review that is much shorter than kind of an on-site review, and alternate that with a on-site review. And that really is much more efficient. It allows the funder to understand what it is we're doing, but without the same investment of time and resources, both for the funder and the legal aid program. I think there's ways in that process that if there was a program that there was concern about, then in the case of the federal agencies, they of course go on site if needed. So sort of establishing criteria for different ways of doing review, and the frequency of those reviews all are a part of efficiency that makes sense to me. So thank you again for the opportunity to comment.
Catherine, this is Rich Reines. Just a question. When you have on-site reviews, what persons, by character, who is it that represents the funding agencies, whether they're federal or private, who comes to visit you?
Most of our money is federal, particularly the ones that we get reviews from, and it would be a representative of the funding agency. It often involves a peer program. In our case, often it is Texas, because Texas and California are
joined the
two largest
conference.
programs. Sometimes it involves a client representative. And then there's always a fiscal review that's a component of it, which is again a federal funder. So it's about 4 or 5 people times the number of programs. They don't all come the same year, which is also good.
Thank you. Jim Meeker.
Yeah, Catherine, when you talked about the review process being on a cycle, phone, then on-site, then phone, what's the period of time between those? Are those every year, or are those every
Has
there's
left the
about every 3
conference.
years.
every 3 years? So
So
3
it's
years there's a
phone,
phone, and then
and
3
then-
years there's an on-site.
Right.
Okay, thanks.
Thanks very much.
Thank you.
Morning, Rocio.
Have a seat.
Good morning. My name is Laura Holtzman, and I'm the managing attorney at the Alliance for Children's Rights, and I'd also like to thank you for your time this morning. I've also participated as a member of the Reboot Committee since it started. And I wanted to take this opportunity as an agency that receives both IOLTA and EAF funding to talk about the goals and the accomplishments of the Reboot Committee. I know you're going to talk about that today. And as Catherine mentioned, the Reboot Committee has taken a lot of time, and there was a cross-section of representatives from many agencies, both CEOs, managing attorneys, data experts, and other leaders from legal services communities who worked together tirelessly, really, over many years with the State Bar on joint goals to, which appear to me to have many of the same overlapping concerns that have been raised by this committee. And there were 3 goals at the beginning of that committee that we really were working together to streamline the grant-making process, review the data that was being collected and reported to the State Bar, and find ways to share the impact of the work that legal services was doing in order to raise more funds for legal services. Through the Reboot process, some of those goals have already been accomplished. Streamlining the grant-making process was one of them. One of them being that we moved from a very antiquated paper application process to an online portal system. And that was no minor feat. And that took several years. And that was something that was done with the working together with all of the legal services agencies to be done in a way to make sure that it met both the state bar's needs and the legal services agency's needs. And I won't take you through that process or waste your time. But another success was actually merging the IOLTA and EAF application and budget process into the same timeline. Also a timely process, a time-consuming process, but so that those separate timelines became a single application timeline and budget process, as you all know now, which benefits both the state bar for administrative purposes and our agencies, because there was a lot of duplicative information that was being asked multiple times a year. And that finally happened over the course of several years in 2016. So those were some things that happened over this process that are in place now. And then the review of the data has been a very daunting goal. Thankfully, we brought in some data experts to help the legal services agencies as well. And it's a very challenging issue to look across, close to 100 agencies to figure out how to collect the same data and make sure that data is accurate. And that has been a very time-consuming process. And you would think that it's simple, but it's not, and as we've talked about repeatedly. But something as simple as gender can be very challenging. So something that we report to the state bar, male, female, unknown, is not that simple, because we're not giving you at the state bar transgender. And then even if you drill down further, there are ways to separate transgender even more. And so there's a lot of data that really needs to be looked at further, and each data component could take a lot more time and attention than we've even given it yet. So there's a lot more work to be done that hasn't been done at this point. But the goal really, as I mentioned earlier, was to make sure that we were trying to measure the impact of the work that's being done by the legal services community to ensure that we were able to tell the story of what the funding is doing for the nonprofits, and doing that in a way that really shared that information. And so the first full year of data collection from that work is about to be shared. It hasn't come out yet. And so there's a lot to be learned from that. And it's based on aggregate data. But the data that has been collected was never designed to be evaluative of each individual program or to prove whether or not the programs were efficient in those programs itself. And if we wanted to collect that data, it would be a very different type of data. And so we have to remember that. And so I just want to remind folks that this committee, who's been working together now for well over 5 years, is a cross-section of folks from the legal services community who now has been working on how to collect data, what data to collect, what data is out there. And if we're concerned about, what data is needed, this group is a really important group to engage, and who's very concerned about what the needs are of the legal services community, and can be of real value to this group moving forward about what data is needed to measure the legal services needs. And this is a group that's very concerned about how we help legal services moving forward. And I want to thank you for the time and attention to this population and how we're serving our legal services community.
Thank you. Any questions?
Laura, this is Rich Reines. Can you just briefly tell us what you meant by the phrase "met the needs of the state bar"?
Well, I think that there were goals in terms of streamlining. And, as I mentioned, there were 3 goals that were communicated to us as we started in terms of streamlining the process and making sure that there were ways to communicate what the agencies were, how the legal services community was serving the clients that they were serving. And that there was no way to aggregate the data that was being collected and reported to the state bar previously. And so by moving to an online portal and coming up with ways to report the data in a consistent way, that was the goal of trying to measure the impact of how we were serving the legal services community. But it was about coming up with a aggregate way to report that data. So, for example, in a very simplistic way, like the Alliance and Public Counsel both do guardianship work, or we both do adoption work. And so how do we report that data in a way so we can talk in aggregate about how many clients are being served and what the benefit of that work is? Does that make sense?
Yes.
Okay.
Any other questions?
Selena?
I was just going to echo that before the community moved to online reporting of case closures and clients, it was a complete paper process. And so what my organization did is actually the data entry of typing in the number of clients served in each area. And so we never had a true statewide picture. All we had was me inputting into, with all of the issues around data entry of one person. All we had was me putting into a system saying, oh, we closed X number of immigration cases, X number of housing cases. And so that's all we had. But now we actually can run really amazing reports and get some more detail than just closing cases. And that was part of Reboot.
This question for both of you, just as a matter of my understanding. CSR reports are reported with regard to clients that have been engaged in the prior year, correct?
Correct.
And when you do an adoption, for example, which I understand you do, how many clients do you identify as being served?
So we would only report on cases that were completed in the prior year.
And if you completed an adoption and identified the client, who would the client be?
For the Alliance, it would be every child whose adoption was completed.
Okay, thank you.
Mhm.
Any other questions?
Greg Fortescue.
Has joined the conference.
Morning, Greg. Thank you very much, Laura.
Morning.
Other members of the public who would like to come forward at this time?
Rich and Debbie, while you're waiting for that, this is Sean Seleg. I just want to note that I joined by phone.
Yes, we heard
Welcome.
you. Thank you.
Nice to have you here, Sean.
Good, thank you.
Thank you. Any other members of the public? David Lash.
I'd also like to reserve for later. I was going to make some comments, but this lengthy handout, I'd really like to know more about it. I think it goes to some of the comments.
Thank you. I think we have some new visitors. If you've just joined us, if you'd like to identify yourselves as members of the public for our roll call purposes. Kim, we're taking public comment now. Did you care to make a comment? Thanks very much.
Okay, I think we're going to move now to, I think Rich has some opening comments.
All right, thank you. The Stakeholders Working Group convenes today with the benefit of 3 prior very informative sessions during which we learned much about the IOLTA program and the importance of IOLTA and EAF and other grants to qualified legal service providers and to support centers. At our last meeting, using a list of prompts, we received statements from grant recipients and non-recipients on simplifying the grant-making process, possibly identifying core programs, changing support center funding methods, expanding the number of clients served, which is a refrain we've heard from many, evaluating the role of impact litigation and whether there is any benefit to changing the Trust Fund Commission's role. We considered issues of data gathering and impact analysis, discussed the impending justice gap study to be undertaken by NORC, and then heard presentations on issues that might arise from proposed legislative amendments to IOLTA enabling legislation. In these presentations, the successful history of the IOLTA program was documented. This is a program which is self-funded, which supports more than 100 different nonprofit agencies in every county of California, and which reaches hundreds of thousands of California's poor every year, but not enough of them. Some of our presenters in prior meetings rightfully noted that time might be better spent in expanding resources for the poor than on how to amend the grant-making process. Notwithstanding, we still must consider the method of grant making and determine what changes might be made, if any. It is intended that this meeting and a meeting now scheduled for January 9th of next year will conclude with decisions as to what action, if any, the working group will take. I suggest we move on to the proper role of each of those responsible for grant making. Not based on the history of the program necessarily, but rather based on an ideal interaction within the statutory framework. What would best serve the poor of California as relates to distribution of funds for legal services and access to our system of justice? We ought to consider which of the constituents possesses the requisite skill set to properly distribute the limited resources to worthy grantees. If we could start with a clean slate, what would the grant-making process look like? Today, we will learn in greater detail the functioning of the Reboot Committee that convened under the auspices of the State Bar for several years. Now I understand it's 5, thanks to Laura. Considering the functioning of the Commission and the grant-making process, with a view to streamlining that resulted in bringing all grants to a single period, collapsing the EAF and IOLTA applications, and performed other tasks about which you will hear more from other presenters. We also have in front of us a matrix that we received, and we will turn to the essential question of the role of State Bar staff, the Commission, and the trustees in the grant-making process. We will consider altering responsibilities and practices based on the existing legislative and regulatory scheme. This may turn on a determination that more and different data must be collected before making recommendations as to any significant changes. We have learned that LSPs and SCs do gather data not presented to the working group, which may be very helpful in this process. One issue before is how to harness that data, and with this opportunity, the working group would benefit from a list of useful information to be gathered to better evaluate the current IOLTA program. Time permitting, we would like to discuss additional measures for State Bar that the State Bar can take to support the legal services programs. Convening the working group is part of a larger examination of State Bar sub-entities. Each of those entities performs a different function, and the Legal Services Trust Fund Commission's unique role is borne by statute. Commissioners undertake resolution of thorny issues confronting bar staff, the day-to-day managers of the IOLTA program. Staff's ability to leave the ultimate decision of a challenging application to a higher authority is useful. That has been my experience. Why isn't that higher authority the Board of Trustees? This is a question before us. The simple answer is that resolving such matters requires time and experience, neither of which the trustees have. The Commission resolves these challenging questions and shields the staff from direct repercussions of such decisions on grant applicants, and the Commission acts as a buffer between staff and trustees. In both cases, the central role of the Commission is to assure that the IOLTA program functions as per the legislative intent, equitably and reliably. The decision-making process is driven by diverse views of clients, lawyers, judges, court administrators, and academics who serve as commissioners for at least 3 years, and in some cases, even donut makers. In that way, the makeup of the commission is quite different from the staff and quite different from the makeup of the trustees. The diverse composition was intended to provide a one-of-a-kind platform for different stakeholders in the IOLTA program. So the question before us is, should this change? And if so, in what way? Communications between staff, commission, and trustees must be addressed. Should a trustee serve on the commission? Should the Board of Trustees receive more regular reports from commissioners? What other methods should be employed to increase transparency? Frankly, these are easy fixes. State Bar trustees inherit an organization that is pivoting, and the State Bar's functions may no longer align with a reasonably well-functioning IOLTA program. That must be assessed. we may find as a working group that the state bar, not the commission, should step away from the process. During our deliberations, I ask that each of you make a list of suggestions you would propose be made by the working group to the state bar to be discussed in our final meeting next month.
Thank you, Rich. I'm going to defer my opening comment to Trustee Sean Saleg, who's on the phone. So Sean, if you're ready, you can go ahead.
Thank you, Debbie. So I've been a little distressed as I've been listening to the deliberations about how distressed some of our commenters have been and at the frequent comment that people are unaware about why we're here. And so it looks like there's going to be a PowerPoint presentation on this as well, but I want to give some background to why we're here. In the last few years, the Board of Trustees and its executive management has been engaged in a comprehensive reform of the state bar, which has long been viewed as dysfunctional. And one of the things, some of the principles we have applied to that are increasing transparency, accountability, and compliance with statute. One of the ways, or one of the groups that has studied these issues carefully was the most recent Governance in the Public Interest Task Force, on which I served. And we looked at all aspects of the bar's structure in an effort to try to make it a more rational and a more governable system. One of the things we discovered was that the bar had grown over the years to become something resembling a loose confederation of organizations rather than a single organization. That created governance problems. It created problems with staff and volunteer entities being siloed, operating on their own, and sometimes acting at cross purposes. So this was one of the problems that the task force identified and addressed certain aspects of it directly and identified other aspects for study. That's the famous Appendix I we hear about all the time. And this review is part of that Appendix I review, a topic that was too complex and too important for the task force itself to cover during the time it had to operate. Let me just say, preparing these remarks brought to mind a comment that Bob Hawley made at a seminar about the future of the State Bar a few years ago. Many of you may know Bob. He was the Deputy Executive Director for many, many years. And he identified the central problem of governing the State Bar is that everyone thinks he, she, or it is in charge, but no one really is. And so that's one of the problems we're trying to tackle for the bar overall. And what I'd like to assure members of the commission and people who have expressed comment is that this is not a process unique to the commission. It is part of an overall look at the state bar's structure, operation, and governance. And so let me move on to a bit of substance. I think I can safely speak for my fellow board members in that we have shared values with the commission and with those who have offered public comment. We all agree on the importance of providing services, legal services to indigent Californians. We all agree on the importance of the funding streams that the commission administers toward achieving that goal. And just speaking for myself, I've heard loud and clear the value of continuity in funding and the inadequacy of current funding, which is currently being studied in the Justice Gap process, as I understand it. So, in other words, we're on the same page as to goals. We're talking about means, not goals. I think there is a myth out there that I want to dispel right now, which is that the board is not aiming to capture these funds to use for funds for purposes other than legal services. To the best of my understanding, that would not be permitted by statute, and I can assure you as a board member I would not support or permit, if I could stop it, the use of funds for a purpose that is not statutorily permissible. And the question at hand today is not whether more funds should be found. There's a consensus by our commenters that more funds are needed. But I have been really quite concerned at the comments I've heard, and I've heard this several times, that the amount of money the commission administers is small, and therefore the process of looking fresh for the first time in many, many years at how the distribution of these funds is administered is something that is not a worthy task, something that the Board of Trustees should stay out of, et cetera. I don't think that's right. I had some statistics pulled, and in the 5 years from 2013 to 2017, the Commission has administered distribution of nearly $200 million. And the average grant that the Commission has made is $400,000. So to my line of thinking, these are not small amounts of money, and the amount of time and energy we're putting into taking a fresh look at how these grants are administered is a worthwhile task and an important task. I think all of us on the board and on the Commission have a fiduciary obligation to ensure these funds are administered well, consistent with statute, and consistent with good public policy. More importantly, there are leadership and stewardship roles to play. So that brings me to some conclusions. Under the current procedures and practices, the Commission is effectively operating independently with no accountability. And that's not to say that a good job hasn't been done or there's been wrongdoing, because this is the way the board has allowed the Commission to operate for many years. But the board's lack of involvement, in my view, involvement in and oversight of the Commission is troubling. It is not consistent with the board's statutory duties. And so we are going to need to think about how to balance accountability to the board and the process and experience and expertise that the Commission members bring to us. So it's absolutely right that the Board of Trustees is not situated to have the type of expertise or institutional knowledge that the Commission members do. I've heard that loud and clear, and I agree with it. But that doesn't mean that the board doesn't have a role to play in administering these funds. The dollar values that I have just described indicate to me that this area of operation of the bar should be one of the board's highest priorities. It's a very large sum of money and a very significant part of our overall budget. So the fact that the board has been so hands-off in this area for many years is actually of some concern. And so I think with that, I will stop. I just wanted to offer that perspective as to why we're here, and also to say that, you know, I think this is a time when, as with so many areas, other areas of the bar's operations, that some change is going to be needed. Change is always difficult, but that doesn't mean we should shrink from it. We need to look at the right way and think about the best way to reintegrate the Commission with the board so that we can operate together cooperatively.
Has joined the conference.
As one organization. And I'm done.
Thank you, Sean. Did you have anything else?
No, that's it. Thank you.
Thank you. I just want to echo what Sean has to say, that we are here because we do have a fiduciary responsibility for the money that's being that's coming out of the state bar, that we should have some oversight over. I think the public demands that. As a public member, you know, I'm not an attorney and I haven't been on the board very long, but as a public member, just sort of seeing this with fresh eyes and not being involved with any of this for years past, it seems like there is an oversight responsibility of the board that needs to be recognized and needs to be, you know, brought forward. I think the public, you know, anyone, if you sort of talk to people off the street, in which I've sort of been doing as a public member, well, they're like, well, yeah, I don't know why you guys aren't, you know, looking that over. That's what we think you're there for, and I think that's what one of the things we really are trying to get to. You guys are doing fabulous work. I don't know that anybody on the board is saying that there's not good work being done. That absolutely is obvious. But there's also a sort of a disconnect as to what's going on with how you're operating and how the board had this hands-off quality for so many years. And because they were so large and sort of this loose confederation, as Sean described it, you guys just sort of did your own thing, which is great in terms of a lot of the services you were doing. But in terms of sort of this fiduciary responsibility, that wasn't really happening for the board. And at the end of the day, if it ever is brought out that whatever may happen and we're find ourselves before the legislature, it won't be the commissioners that'll be sitting in front of the legislature. It'll be the board members that'll say, how come you didn't know? Because you should have known. Or why did this happen? Because you guys are supposed to be responsible. As far as we're concerned, the board is responsible. Don't put it off on the commission as to why things happen. That was your responsibility, and that's what we're looking at. We're not trying to get away from what good work is being done. We're not. We just want to be sure that we're doing everything in a responsible manner. So at the end of the day, we all can say, yep, we did a good job, and the people of the state of California's money was well spent. That's all we're trying to do. Yes.
This is Yvonne, and I personally don't disagree with any of that. I think the Board of Trustees does need to know, and they are, at the end of the day, accountable for this money and how it's administered. I recall that at the last meeting we had, I don't know who spoke, but I know it was a member of the commission who talked about that historically there's been no interaction between the board and the trust fund commission. There's been no request for the commission to report. Trustee members don't attend their meetings. They're not familiar. There was a push for more collaboration. And I don't recall that was Judge Seligman. But anyway, I think that was all good recommendations about, and I think for me, not having any history about this either, the fact that made a real impact on me. The fact that there is no history of collaboration, there's no history of the commission reporting to the board, the fact that the board has never attended meetings of the commission or been involved, and I think that is one thing to look at, and how is it that we promote that collaboration, that integration, and perhaps listening to members of the working group and the public, how can that be achieved? Because I do think at the end of the day, I do not disagree with you that the Board of Trustees needs to be accountable to how this money is administered, and looking at the ways that could be done and integrating the members into the work of the commission and how it's done.
I know that, like I said, I've only been on the board since February, and I was appointed to be the liaison for the commission and for access to justice and all of that in September. And since I've been appointed to that, I've attended almost everything that I could, almost all of the conference calls. I think I missed like one that I didn't go to, and I've taken that very much to heart. But that is sort of personality driven. That's who I am. We need to have it so that it feels more of an institutional responsibility of the board in terms of that service. It's really, and it is difficult as a board member because there's so many things, because there are so many different entities that we're liaison to do that kind of meeting. I mean, I was on the phone last week. There's sometimes I'm on the phone, 5 hours, 10 hours a week on conference calls that are related to the board. I'm retired. I don't know how anybody who has a job can do that, can devote that kind of time. So for me, it's not that it's necessarily easy, but it's something that I really want to do because I really want to learn. And I think the only way I will learn, as I sit on another conference call and my husband goes again, is I tell him, I said, the only way I'm going to learn how things are working, how things work around there is if I sit in on some of these calls. And that's how I find out my information. So I'm not dependent on whether or not it comes up in a report at a board meeting or whether or not the staff reports it somewhere, that I've heard it myself, that I've sat through those phone calls.
But I would just say that regardless of whether or not we have superstar board members that are also have the time to do that, liaisons to sub entities, participation in meetings is no substitute for an infrastructure approach, which clearly delineates roles and responsibilities. They're not mutually exclusive, and nor does one substitute for the other. And so I think this functional matrix that we'll get into later today is the beginning of that type of infrastructure, and that's really needed, in my view, as the executive director. So irrespective of who's on the board, who's on the commission, and who our staff are, there are clearly written, documented policies and procedures in place that outline the decision-making and oversight structure, and that's missing now.
Judge
Yeah.
Sullivan.
I actually wasn't here at the last meeting, so that wasn't me. I just want to clarify that. It was a good comment, whoever made it, right? I want to echo to some extent what Yvonne said. I completely agree that the State Bar has an oversight responsibility. And I don't know historically why it wasn't happening. Clearly, it wasn't happening to a degree. I think it is important to have an infrastructure that requires periodic and consistent reporting, that the State Bar agenda and the Board of Trustees have a regular line item to make sure there's a report from the commission so they know what we're doing, and to the extent it's appropriate, they approve what we're doing or raise whatever concerns they're having. But I want to emphasize an important additional goal here. It is critically important, I think, for legal service in California that the State Bar, Board of Trustees, and the Commission work in partnership. And I think there's a goal where there can be a synergistic effect. You know, historically, there have been State Bar presidents who've embraced the goal of legal services as one of the critical goals during their term, and that's been great. For the Board of Trustees itself, which brings individuals from diverse practices and a lot of connections, being part of that process is very important. One of the issues that was mentioned, you know, we have a certain revenue stream, but one of the goals of the commission and one of the goals that I would assume of the State Bar is to increase that revenue stream. And that's done by having advocates for legal services at every level. So I completely agree that setting up structures to make sure the State Bar is not divorced from this process, is not an absent step parent, but embraces the process and embraces the goal, frankly, the goals of advancing legal services is critically important. So I don't think there's a fundamental disagreement. I hope there isn't to those. I mean, there's some details. How do you work it out and all the rest? But I think there's an important role, which was recognized, I think, by Sean, for the commission, given our expertise, given the history that's out there. And there is a goal, an important goal for the State Bar. But together, I think I don't want to lose sight of the overall purpose here. There's a synergistic effect if we're working together to increase legal services.
I'd just like to follow on Leah's comment for a minute. I agree that you need to go through the procedures and the practices and set up some structures. Of course, the devil is in the details as to what those ought to be, and I guess that's what the matrix is designed to walk us through, or at least elicit some discussion about. I do, however, want to say that taking those liaison duties seriously, I mean, back in the day when I was on what was then the Board of Governors, we were required to go to the meetings for the groups for which we were liaisons. And it's really important to do that because when you do have an agenda item in front of the Board of Trustees about, let's say, the Legal Services Trust Fund Commission or its report or what it wants to do with the money, and Debbie's sitting at the table and she's been to all the meetings, she's going to have a different perspective than people who are coming to it on the cold paper record. And so I would, you know, if we're creating structures and oversight responsibility and a set of rules governing that, I really think that ought to be part of what you do. Because if you have somebody who's participating in the meetings, who's able to ask questions, to have an exchange with the commissioners, then you're going to have a much deeper perspective about the whole thing than just what's in your agenda materials. But I don't disagree that other things may also be required. It's just, what are those things?
You know, I agree. I do, and I said I agree with Leah too. But I said it is both. It's not just, you know, the liaison part, but it's also having it sort of in structures that this sort of communication happens between the two. And I love the fact that what Seligman, what you said, excuse me, the synergistic approach for the two of us to seek more money and seek funding together as a group is really could be a very dynamic thing. And I think that that is, from my perspective, something that I think we should be working towards, because I think to have us both do, because there is not enough money for legal services, obviously not. And as Sean said, it's not anything that, the funds that are in there is not anything the board is looking to pull out to use for anything other than what it's earmarked for. And that's what we want to do, and we do want to get more, and I personally do want to get more. And as someone whose family has used legal services over the years, I do know the value, okay? Because it has personally affected me in ways that has been very helpful to my family. So to take anything from it, I don't want to do that. And to see some of the people who, some of these organizations, because I have family here in LA who have used those services, and there may be some people who have been here who have helped them. And I appreciate that. I truly do, because there's no other way that they could have gotten that help if there hadn't been legal services available to them. So I understand that very well. So I think.
Selena?
I have just another comment, of course, in support of Judge Morrow's and other comments about the structure. So we have a structure now where the Legal Services Trust Fund Commission reports to the Board of Trustees, at least on an annual basis. But it largely is, I think, a somewhat shallow reporting. There's a paper record, and I'm not sure how many Board of Trustees members actually read the entire record, but there's a very good report each year about the programs, and it's all packaged with the recommendation for distribution. And we do have liaisons, but what I see as a member of the public who attends the Trust Fund Commission meetings is that frequently there are Board of Trustees meetings at the same time. And so sometimes liaisons actually cannot go because they can't be in two places at once. And I've seen them actually go from room to room trying to do both. And so there's small little structural changes that actually could make the liaison role more meaningful, where if we can ensure, calendaring to make sure they can actually go to their liaison positions. Because I do think that there is a structure in place that could be strengthened without a whole bunch of changes. But I think that the Board of Trustees just needs to understand a little bit more of what the commission does.
And I think this whole stakeholders process has given us a better, at least for me, has given us a deeper understanding of what the commission does. And I think that that's been very valuable. And I think in terms of the whole board, I think that it has been valuable because Sean and I have participated in this, and we'll be able to relate what we've learned to some of the other members. I agree about the double booking on because that that's like how you do. I think there does need to be a master calendar. I think that is one of the tweaks, just because we did have a board member who had to be at a CBE meeting at the same time she had to be at a board meeting, and so not just with this commission, and that's the problem too for board members. It's not just this commission, but then you have examiners and you have all these other meetings that happen that we have liaisons on. That it's just it is very difficult to make a lot of. Plus the board itself is much smaller, I think, than when it was Board of Governors. There's fewer members. There's fewer members, and there's vacancies, which hopefully Gavin Newsom will fill when he comes in. And so there's even fewer. Huh?
Maybe not January 8th.
Probably not. But it's just so there's just fewer of us to even go around. Okay, we're just sort of there's only so much you can do. So I think that this was I'm hoping, and I was happy that Sean wanted to sort of take the lead on this because he has more historic knowledge than me to speak out, and that this would sort of set the tone as to what we're trying to do. So because this is our last two meetings, and so let's sort of really get down to the meat of it. Okay.
I'd only add to that, this is Rich, having made the presentations to the Board of Trustees for the last 3 years, each presentation did amount to a considerable amount of money. It was my experience that the board's role was more or less a rubber stamp, and I think what we're all asking is that it be much more than that, and that it be an informed approval or disapproval, and that questions be asked more frequently by those who have an understanding of what questions to ask. So hopefully as an outcropping of this effort, we'll get to that point. And now we are going to move on to item C, our business as stated on the agenda, and item number 1, the overview of the reboot committee. Turn it over to Corey.
Has left the conference.
So for those on the phone or anyone who's,
Corey, did you send the PowerPoint such that we can, okay, because we need to send it to the folks on the phone. Can you send it to Ellen?
Sure, yeah. Yeah. So for those on the phone, my name is Corey Friedman. I'm one of the co-chairs of the Legal Services Trust Fund Commission. I have a PowerPoint, working group members. I guess that's going to be emailed to you now. Members of the public, you can request it, I think. It's nothing too extensive, so if you're just listening on the phone, you're not really missing all that much, so I wouldn't worry too much.
They can open the webcast and they'll see your screen.
Oh, and it's on the webcast. I didn't realize that. So there you go. So I've been asked to talk about the reboot process, and I think part of the reason I was asked was that it's been mentioned in previous working group sessions, and there's interest in what it consisted of and what it has resulted in, and I think also it's a good way to talk about the role of the commission, the role of the board, and staff. So I'm going to try to focus on governance a little bit, since that's the topic of conversation for today. Certainly, I'm really happy to hear from Sean's comments earlier that the Board of Trustees is considering the distribution of this money to be a major priority. That's really fantastic, and so hopefully this presentation will help provide a little bit further information about what has been going on over the past few years. And as far as governance issues go, probably at the outset, I should say that since I'm going to be talking about who does what tasks, that if I refer to State Bar staff, I'm referring to the people who are actually staffing the commission and administering the grants, handling the bank side of the IOLTA. These are State Bar employees who work for what was formerly the Office of Legal Services and now is the Office of Access and Inclusion, as opposed to State Bar management, which would include Ms. Wilson here, and that's because the State Bar staff is not necessarily interacting directly with the Board of Trustees in the same way that senior management is. And I just want to make sure that I'm not confusing people when I talk about who is doing what. So the reboot project. You've already gotten an introduction to this from public comment, but basically reboot of IOLTA was re-examining the IOLTA process from two angles. One, streamlining the applications and reporting for the sake of efficiency, and the other, collecting data, further data from programs, particularly data about outcomes actually achieved for clients. That may sound awfully familiar to the members of this working group, since some of the meetings have touched on these issues, and we may be asked to opine on them. It's not quite clear. So perhaps I should start by distinguishing a little bit the reboot process from this working group. Reboot, as you have heard, was a very much in the weeds type of process. It took years, and it also involved the entire legal services community, the grantee community. So it started with ideas that came from the community to a large extent, especially with regard to the streamlining aspects that came from grantees. And then grantees have been, in many ways, the people who have put in the most significant effort in making this a success. They were working with staff, and it was a joint process between staff and programs, but it was very detail-oriented and lengthy. Very different from what we're being asked to do today. Just in case people are wondering if we are walking the same road twice. So how did it start, and how did those ideas get generated? Basically, in 2012, the State Bar convened statewide meetings involving all the grantees. I think about 80 programs were represented. Commissioners also attended, and there was brainstorming sessions.
Margie Estrada as public participant.
There were
Has left the conference.
so brainstorming sessions to figure out how the process could be improved. And a few things came out of that. One was a recommendation that the grant year be changed. You've heard about that during public comment earlier. That is a really big deal. It may not sound like that if you're not familiar with it, but previously IOLTA and EAF were on different cycles, and the cycles were not intuitive, and they didn't really match with a budgeting year, and so it was awkward and time consuming. The other thing was online grant making. Again, that was a huge improvement, I think, on both the bar side and on the grantee side. And the other thing that was discussed was the collection
Has joined the
of
conference.
mean benefits. So, as has been previously stated, and I'm going to give some examples of this later on, these are the actual concrete achievements that have been, that providers have gotten for their clients. The idea is if you ask an attorney, what did you do last year? They're not going to say, I settled 15 cases and leave it at that. They're going to say, I got a settlement of, X amount of money, and I did this for that client. And those are the real results that that we can now discuss and disseminate and present to potential funders. So as far as the streamlining goes, I'm just going to mention a bit of that very quickly. It's rather than getting into the details about how it worked. If anyone has any questions about it, though, there are plenty of people in this room, both on this working group and members of the public, who could describe better than I the efficiencies that they achieved. As I said, one is merging the IOLTA and AF applications. The budget forms were improved. That was also a big deal, having to do with county by county budgeting without boring you with the details. The fiscal to the calendar year change and the online automation onto Smart Simple. And that also made all of this data collection possible. I don't think the bar staff would have really been able to use and manipulate this data if it was on paper and some poor person was entering it into an Excel spreadsheet, as Selena said she was once doing. That really wouldn't have been possible. I think mentioned in the last meeting was the fact that Smart Simple auto-populates from one year to the next. I think that's probably responsible for a lot of time saving. And I'll give you some ideas about the timeline here. And this also goes to the different roles of the staff and commission members. So like I said, in 2012, this started with the statewide convening. Then in 2013, the commission voted to approve these calendar changes for the IOLTA and AF, and to approve the overall goal of collecting Maine benefits data. And this then went to the Board of Trustees in the February 2014 meeting. The trustees were briefed about the idea of the Maine benefits collection and the fact that this was going to be a different grant cycle than had previously occurred. And the board took a vote on a 6-month grant year, because in order to align these two cycles, you needed to have a stubby half-year grant. In fact, I think there may have actually been I'm not sure about this, there may have in fact been 2 votes, one for the total amount and one for the individual disbursements to the programs. So I think the Board of Trustees actually heard about this in 2 separate meetings. One, because there's the pot of money that was going to be dispersed for all providers in that 6 months, and then again when we had numbers for each program. And that is sort of how things are brought to the Board of Trustees generally, in that the commission will take a vote on disbursements, and then it does go up to the Board of Trustees for a vote before it can actually be dispersed. The staff actually calculates the formula. That was mentioned in our first meeting. So the commission is not saying there needs to be a little more here, a little more there. That all goes by the formula, which is performed by staff. But the commission does take a vote on the total package, and again, that goes up to the board. Another vote that the commission took relevant to this process was to approve a staff proposal to evaluate those budget changes that I mentioned. And then after that, a lot of the heavy lifting started. It's worth saying that although this has been called a reboot committee, it was not really a committee of the commission, it was a staff-led process. So the staff was working with outside experts in the form of people from legal services providers with expertise in the various subject areas that were going to be addressed, which was pretty much all subject areas, in fact, that any low-income person in California might want to seek legal help for. So when dealing with questions like how should we change the budget, while the commission might vote on the overall idea, the commission does not approve every single change.
This subscriber has left the conference.
A lot of that is left up to staff. And a big part of Reboot was this online process, and that was reported regularly to the commission, but of course the commission is not choosing vendors, is not going through the process of actually getting applications online. Likewise,
has left the conference.
the process of assembling the main benefits was really a collaboration between State Bar staff and all of the grantees who were volunteering their time to come up with the main benefits and the economic benefits and how that was going to be evaluated. However, all of this was reported regularly to the commission. Throughout this time, there were commission
Has joined the
liaisons,
conference.
including myself, who were assigned to
Margie
participate in
Estrada,
this process.
Has joined the conference.
Actually, one of the first commissioners was Donna Hershowitz, who is now chief of programs, I think, for the State Bar. But at the time, she was a member of the commission. So she was actually involved right in the origination of this whole process. I joined the commission shortly after. Professor Meeker has been involved now for a while, and he was recruited to provide particular expertise. But this is very different than, say, the partnership grant subcommittee, or the eligibility subcommittee, where the commission is taking votes and serving as decision makers. And that didn't happen here because it was really a matter of getting information from outside experts and processing it and handling it. So commissioners were involved, but they were not serving the same kind of role as they would when they are evaluating, say, grant applications. By the way, when the bar became subject to Bagley-Keene, the role of this outside experts was reevaluated just to make sure that everything was copacetic, and we were advised that a panel of outside experts convened by the bar, an ad hoc group, would not necessarily become subject to Bagley-Keene just because there were liaisons from the commission. So the main benefits and economic benefits were evaluated from 2014 to 2015. They continue to be considered, and I will show you some examples of that in a minute. 2015, the actual shift in the grant calendar occurred, and between January and June of 2016, depending on the program, grantees became required to collect this outcome-based measurements. Before that, volunteer programs were collecting it to test it out. So the first batch of data was not usable enough for the bar to really disseminate it. It took a while to work out the kinks, to make sure that the programs were collecting data in a consistent way, to make sure that the main benefits were correctly articulated. But the bar staff still put together an impact report based on that as basically a test run to see how that would go, how they could use that information, a mock-up of what it would look like. And as someone mentioned earlier, the first real set of data is currently being used for a new impact report that should come out in early 2019, and that will be really exciting. Another role that the Board of Trustees has had just in the past year is listed there, that in July and October, a rule change was proposed to align audit rules with the new grant-making calendar. As this shift to this new calendar has taken place, it appeared that the audit rules didn't quite mesh. That's another example of how the commission interacts with the Board of Trustees. Whenever there is a rule change that the commission might propose, we would take a vote, but it would have to go to the Board of Trustees, and it has. The commission does not have any power to change state bar rules. Now, throughout this whole process that I've outlined here, State Bar staff were reporting regularly to the commission with the help of the commission liaisons about what was happening. Likewise, State Bar staff reporting regularly to the State Bar management. So that includes not just Ms. Wilson, but also her predecessor, since this process predated her, I believe. So why did it take so long? People may be wondering. As far as the online applications go, I think if there's anyone here who has implemented a document management or e-court system or any new technological fix in his or her office, you probably know that new technology is very valuable in the long run and involves a big investment of time initially. So that could not be done overnight. Also, as I mentioned, the grantees and staff, with the assistance of commission liaisons, were trying to find a way to describe what it was they did in all of these substantive areas. And when you look at them, you can see that any one of these could be carved up into a bunch of different subcategories, and that the amount of different work you can do in that area is vast. Consider employment, for instance, or income maintenance. So the grantees who participated in this were asked to find a way to describe all of the achievements that they got for clients and then to roll those up into bigger categories so that there wasn't an overwhelming amount of information, and to do it in a way that you ended up with data that was accurate and compelling and that could be understood from program to program. So that is no small feat. To give an example, though, of what the value of doing that is, here's some information from 2017 for domestic violence matters. So previously, we could only talk about what's listed there as outputs. We closed 15,028 domestic violence matters. And that's great, but it doesn't tell you that much in a way that's going to draw you in and show you the human side of this. Now, you could say that grantees obtained nearly 5,000 restraining orders to protect survivors from abuse and $2.5 million in child and spousal abuse. And then what's listed there is social science analysis. This information can be used by academics, such as Professor Meeker or others, in connection with existing social science research to provide an even broader picture of the economic and social benefits of the work that grantees do. So here you can see it says that there's 2.9 to 3.9 million in avoided Medi-Cal costs, and that's just for the 231 restraining orders that were achieved after hearing. And I think that asterisk is important because it's worth saying that these are very conservative numbers. And the reason that they are conservative numbers is that it was decided that this should always be defensible so that grantees or the state bar can take this information out to funders, can take it to social science researchers, and can be confident that it can't be knocked down. It's not going to be inflated. The numbers are undoubtedly even higher than this. So I've been talking about main benefits, but that's probably not a useful term if you have no experience with collecting this data yourself. So what is a main benefit? Here's some examples from domestic violence. And you can see a little bit what I meant about describing the work people have done in a way that rolls it all up into categories that are not too overwhelming for programs to use, but also tell you something valuable. And just to give some examples of the kind of questions that came up, there were substantive issues about what kind of cases to count, whether it needed to be full representation or not, for instance, and how do you balance capturing everything, with keeping it simple. There was also logistical questions about how to incorporate this into intake processes. When do you start counting? How many benefits can you count? Do you count multiple benefits for a single case? And the answer there we decided was yes, you can count them all, but you still then need to avoid double counting, and that was another discussion. These keep being refined. For instance, that number 4 there was obtaining restraining order after hearing or renewal order. What we heard from practitioners was that pulling that out was really important. That's not something that anyone would know unless they practiced in this area, and that's really why the state bar staff needed the time and effort and expertise of the grantees. You could not come up with a list like this unless you practiced in the area. So another example here, housing. We could previously say there were 52,000 housing cases. Again, not super compelling. It's a big number, but it's not as concrete as the fact that nearly 5,000 people got to stay in their homes, or that $43 million were collected by clients, and there was a $19.5 million reduction in claims. And that was another issue, that we were collecting not just the value acquired for clients, but also penalties that were avoided or costs that were avoided. And here's an example from the mock-up impact report. What the bar staff are working on now is developing one for the 2017 data, but it will be all pretty and designed like this so that the state bar can use it to hopefully get more money for legal services. And it's really great news that that's going to hopefully be a priority of the Board of Trustees. So I just wanted to close by saying that at the end of the last working group meeting, Ms. Manning mentioned that the reboot process was something that the Board of Trustees did not have sufficient information about. And as you can see, it was brought to the Board of Trustees as a vote. However, that was quite a while ago, and there's new members of the Board of Trustees since then. So I do think it's worth asking, how can this kind of information make its way up to the Board of Trustees? It would be a little difficult, I'll say, if the Board of Trustees wanted to take actually a vote on changes to reporting requirements. Changes like that are made all the time, and so that would require a lot of time spent briefing Board of Trustees members. So I'm guessing that probably what the Board of Trustees would prefer would be regular reporting. And I do know that, like I said before, staff reported constantly to the commission, and that they also reported to senior management. But if it then needs to be reported out from senior management to the Board of Trustees, then perhaps that could be built into the Board of Trustees schedule. I think that's something that the board needs to discuss, exactly how much time they would want to dedicate to these kind of questions and how to set it aside effectively. Because as it is, rule changes and major changes did go to the board, but it appears at least that the Board of Trustees did not feel it was getting sufficient discussions of what was going on. I might also say that based on Ms. Manning's comments, it sounds like there might been some confusion, and this may or may not be true, but I think maybe I can pinpoint one of the bases for a little bit of the confusion. The Board of Trustees did hire a consultant to evaluate all of its sub-entities as part of the Appendix I review. That's a big job, and there was a lot to consider. But when that consultant spoke about reboot, he did misstate a bunch of things a couple of times. So I think maybe he didn't understand exactly what was going on or what it consisted of. So to the extent that the Board of Trustees was relying on that, it might have sown additional confusion. I don't know if that's the case, but that is my theory. And certainly it does seem like more reporting has been requested, which I think would be a great idea. Does anyone have any questions? Either for me or for anyone else in the working group who participated in this? There's a bunch of people in this room who could talk about it.
This is Yvonne, and my organization is a grantee, and I have very personal knowledge of the process because I was intimately involved in some of the subject matters that were looked at. It was a pretty intensive project. I, in fact, led the discussion of the housing group. Our organization addresses a significant amount of the subject matters that were listed there. We dedicated another senior manager and middle manager that participated in the domestic violence portion of discussion, where grantees elected the subject matters that were of not most importance, but an area where they wanted to dedicate real input into. And so it was our organization, Elected Housing and Domestic Violence Family Law. So it was a pretty intensive process. A number of discussions were held, bringing together the grantees and just the discussions of how we would measure. As you said, there was a litany of measurements we wanted, and then how do you take that litany and then consolidate it into some major headings was a task. But I do have personal knowledge of this process. I think it was extremely meaningful. It was the grantees that participated committed a significant amount of time and expertise to this on a volunteer basis. But it was important for us, not just because the state bar was going through this process, but it was important to us as organizations to look at having good data to measure the impact of our work on the population that we serve, which is low income and poor individuals and families. So that is one of the reasons we committed so much resources to this effort. And we do believe it brought about a streamlined system. Just, I'm not even going to address the administrative side, but that certainly was a great change. But on the data and the measurements that we have today, the ability to capture this data, the training that went on to train staff, and the build out of data systems in order to capture such data, this was all pretty significant, and I think reflected a great deal of commitment on our part, but it was duplicated by a number of grantees. So collectively, it was quite a significant effort statewide on this reboot process.
Professor Maker.
Yeah, I just, I came into the process late, just 2 years ago, so I can't take any credit in working on the committee for the streamlining stuff, but it seems to me the streamlining and the Smart Simple is a great improvement. I worked on other projects in where you get multiple agencies to try to collect the same data. And I think, in particular, the 22 different law enforcement agencies in Orange County trying to collect the same gang data. And I can say that this group has made a lot of progress, but generally you have to look at this as a long term. It's not just a reboot project that starts and then finishes and it's over. You have to continue to monitor your data. Things change over time. For example, right now, one of the things I'm trying to push the group to work on is the difference between structural zeros and true zeros. That is, all of these agencies don't work in all those 15 areas, right? A lot of these agencies only work in one of those 15 areas. A lot of them work in almost all of the 15 areas. And so if you're not getting any return in a particular area because your agency doesn't work there, well, then that's a structural zero, because you would never have anything in that category, as opposed to you just didn't recover anything and say childcare that year because you didn't have any cases, in which case that's a true zero as opposed to a blank. But as they move on and we get everybody to think about the data the same way, then you're going to really improve your ability to do more with the data than just give sums, right? Because once you really know what your zeros are, you can start doing things like measures of variance and measures of correlation, and you can get a lot more detailed analysis. And from my point of view, the analysis wasn't just for the state bar. I view this as an issue of collecting data that the agencies themselves can use these data in applications to private foundations and so on. Especially those applications to private foundations will be much stronger if you can say, look, at the state we as a group in the state have developed these measures that we're measuring consistently across different agencies. It brings far more credibility to the data, and hopefully that will happen in the future.
Any comments, questions about the reboot committee's working? I'd like to just point out that in terms of what Corey just covered, the issue before this working group appears, at least today, to be focused on the integration of the work of the commission, the staff management, and the board of trustees, which has, as Sean articulated it, the ultimate fiscal responsibility, fiduciary responsibility for distribution of IOLTA funds. It was not a function of the reboot committee to review the integration of its work, staff management work, with that of the board of trustees, as I understand it, correct?
If I understand you correctly, then you're asking the commission's role in making sure that the board performs the oversight, or that?
No, whether or not the reboot committee considered the reporting requirements of the commission to the board of trustees with respect to the matters covered by the reboot committee.
Whether the commission considered reporting to the board of trustees. So generally, the commission relies on bar management to make reports to the board of trustees, or to at least determine what's on the agenda, and then the bar management would ask commissioners possibly to report. Commissioners usually attend when they are getting the vote on the dispersal, but the commission has no control over the agenda of the board of trustees. And it's my understanding that, at least in the past, the Office of Legal Services, as it was previously called, was not asked was not asked at every meeting, or even particularly regularly, to report on its activities.
Thanks. I mean, one of the issues that I think we have to deal with is whether or not there is an opportunity on the part of the Board of Trustees to become sufficiently immersed in the activities of the commission staff and staff management to ask the questions that ought to be asked by those who are fiscally responsible for the distribution of money. I would venture to say that the 3 times I've presented to the Board of Trustees on making large grants to the various trustees resulted in unanimous votes on each occasion. And I think unanimous votes of a Board of Trustees, regardless of how large or small, tell you that there's not enough questioning going on. But the real question in my mind is, how is this process to become sufficiently transparent to create an environment in which those questions, the right questions, are asked and votes are truly informed? And I'm not sure that the skill sets are matched, the terms of office are matched, the backgrounds of those who are responsible are sufficient to ask the right questions. So to whom is that responsibility to be delegated? That, to me, is an issue that we aren't discussing. The reboot committee didn't get into.
As far as transparency goes, also, just in case anyone's not aware of that, all of the commission's meetings are publicly noticed. They're now Bagley-Keene compliant. And so anyone can participate and any member of the public can come and make comment, and reboot was frequently on the agenda, so there was many opportunities for public comment. In case people are wondering how the experts were forced into there to participate, how we got our volunteers who undertook an effort that I think is best described as Herculean. I did mention that there was statewide convenings at the beginning. Those were not the only statewide activities that took place. There were other in-person meetings, there were webinars, and so grantees were encouraged to participate through all of that. When there was a gap in expertise, staff and other experts recruited people who could fill that gap. So it was really brought out to the broader grantee world over and over again to make sure that the main benefits, as they were set out, would really capture everybody's work. And whenever it seemed like there was an area that was not being covered, people who are participating use their knowledge of other organizations to dragoon other people into this process.
Professor Meeker.
Yeah, I just want to also, I agree with Corey on her analysis of why there may be a lot of confusion for the board on what the reboot committee was. Because of Mr. Schaffler's analysis. I was there when he gave it, and he completely mischaracterized the reboot. He basically characterized it as the grantees determining what data their funding is based on. And that's clearly was not the purpose. We explained to him on a conference call that was not the purpose. But I could see if the only thing you know about the reboot committee is Mr. Schaffler's presentation, that there would be a lot of confusion.
Oh, sorry, pushing the wrong button. I'm a little confused. Are we being asked to do something about the reboot committee as part of deciding this governance question? I mean, I tried to review this matrix and I didn't necessarily see anything on there about that.
No, so the matrix talks about various functions, and where the reboot committee functions would fall has to do with data reporting requirements. Unfortunately, these pages aren't numbered. So when we move to that function, I think that's where you will see the recommendation that as a change to existing practice, all non-technical changes to data reporting requirements would be approved by the board. There are additional issues with respect to the operations of something like a reboot committee. And I certainly think if the committee, I'm not clear on the current status of the committee, but if the committee continues to exist and goes forward, I think we do need to clarify the nature of that body and what kinds of requirements
Has left the conference.
based on its construction. So just to speak to some of the issues you've raised briefly, Corey, on multiple occasions, both the director of that office and the manager of the office reported to me that the reboot committee was a committee of the Trust Fund Commission. So certainly I don't think it's fair to say that this misunderstanding stems solely from Richard Schaffler or the Appendix I process. It was reported to me on multiple occasions that it was a committee of the commission. I think even some of my own staff are surprised to hear now that it was a staff committee. But that being said, irrespective of the past, I do think going forward, we need to be clear about what kind of body it is. And of course, if it is a committee of the commission, it is subject to Bagley-Keene, and the meetings of the reboot committee itself would need to be publicly noticed. And so I think that that's fine going forward. So no intention to terminate the committee. That's certainly not a recommendation. There are functional aspects of that work that are implicated by this matrix. So when we get to that portion of the agenda, we're not quite there yet. I think we could talk about the relative merits of having the board have any role at all in the review of data collection and reporting requirements.
And I will say that I do think, there we go. I will say I do think that it's a status as a official subcommittee or not. People refer to it in as a committee quite regularly, and I'm not sure that that was solidified until we really had to think about it when Bagley came in. So I think that's well taken, that it's worth making sure that it can be constituted in a way that's compliant. That's definitely appropriate. But I do think that it could well be described as staff-led rather than commission-led, although commissioners still had a role and continue to have a role. Also, if people have any governance-related questions about the role of staff in this, Rocio here is intimately familiar with the work of Reboot, and so those questions could be answered too. Generally, collecting data and working with it is usually a staff role rather than a commission role, but that doesn't mean that commissioners have no relationship with the data that's collected. I believe with bank grants and partnership grants, the commission members do review reporting information. I'm not on those subcommittees, so I'm not the best person to talk about that, but that does happen. And then certainly the commission is going to get further information about the results of Reboot and what comes of the impact report.
Any other comments or questions? I'd like to point out that in my experience, the relationship between the commission and staff management has been quite integrated. And invariably, these bodies have worked very closely together to the point where, as a commissioner, I always believed that the Board of Trustees would be informed of anything of importance by staff and staff management, that it was only at the invitation of the board that commissioners would make presentations. But that on the other hand, staff and staff management had the responsibility for and were exercising it to inform Board of Trustees of matters that rose to that level. That may have been an assumption on my part that ultimately resulted in what appears to be a notion that there hasn't been enough transparency or openness in the processes of the commission. On the other hand, I think this process of deciding how matters will be reported to the Board of Trustees so that the board may be more informed when making decisions is very worthwhile. No one rejects that notion at all. I think that's a good idea. And the Reboot Committee itself is an internal mechanism by which the IOLTA program can constantly, in its relationship with its grantees, improve its performance and extend the inadequate resources to as many people as possible. All right, so we're on the agenda. I think we've covered item 1.
Yes. Right.
So we'll now move to governance. That would be item 2.
And I'm going to start. Joe, can you pull up?
We'll take just a minute break to get our administrative organization going here. Joe's got some.
What I thought might be useful, though I think some of Sean's comments earlier covered this, was just to go over a bit of the background on the Appendix I review to put this process in some context. And I purposefully did not change these PowerPoints. I'm using PowerPoints that were presented to the board across several different meetings as the board weighed the governance questions contemplated by the Appendix I review. So to start with, I want to give this working group a sense of the governance principles that formed the parameters for the board's work, or the basis for the board's work that it has undertaken with respect to a review of its overall governance structure. And I'm going to go into these a little bit more later on, but these key principles are role definition, accountability and transparency, clear lines of authority, impartial, consistent, and fair decision-making and engagement. Before I do this, I go into those aspects. I want to provide some context as to the challenges that the State Bar faces with respect to the governance question. This graphic here shows the various functional areas for which the State Bar of California uses volunteers. And we're comparing this here to other licensing agencies in the state. So you can see that the State Bar uses volunteers for all of the functions in the left-hand column other than regulation. And that compares to, I'd say, the dental board and the veterinary board, which use the next highest number of volunteers to perform any of their core functions. So we have a significant proliferation of the use of volunteers in the organization.
Can I just ask a quick question?
Mm-hmm.
How many of those boards actually do grant making? And do you know how much grant making they do?
No, I think that the medical board does some grant making. I don't have that in front of me, but I'm gonna continue on. So they don't all perform those functions. We have another chart that shows that. This here shows the number of sub-entities and the number of volunteers by regulatory agency. So each of those bars, the colored sort of bars, represents the number of committees that each of these entities has. And then the overall scale, the horizontal length of all of the bars together, gives you a sense of the number of volunteers. So you can see from this, the State Bar has over 250 volunteers. The next regulatory agency behind us is the Board of Accountancy with less than 50 volunteers. So our volunteers are performing in many of our functional areas, and we have many more volunteers than other regulatory agencies. Now we're going to get, I think, to your question, Corey. We're looking at the type of bar association. So now here we're just comparing the State Bar of California to other bars. And we're looking at mandatory or unified bars. We consider ourselves now a mandatory bar. And you can see in California which functions fall under the purview of the mandatory bar, whereas in other state bars you see different placements of the functions, notably the functions of the Committee of Bar Examiners and the functions of the Trust Fund Commission in many other states are not being performed by the State Bar, the regulatory bar. So this is some of the background information that the board received to sort of put in context the unique nature of our State Bar, both vis-a-vis other California regulatory agencies and as compared to other State Bar licensing agencies. So with that in mind, the board began to really delve into those governance principles that again defined its work with respect to the sub-entity review. So that first value that I articulated was role definition. And here the board is really looking at, does each sub-entity have a clear purpose that aligns with the mission, priorities, and strategic plan of the bar? So clear purpose, role definition as a core value. Next, we look at accountability and transparency. Does each sub-entity utilize outcome measures that measure the effectiveness of its work? And by its work here, we're talking about the work of the sub-entity. Does each sub-entity report meaningful management information to the board on a regular basis? Next, clear lines of authority. Do the board and the sub-entity share a common and clear understanding of what authority the board has actually delegated to the sub-entity? Do the board and the sub-entity speak with one voice internally and externally? Is the bar management team able to exercise effective control over the allocation and the use of state bar staff and resources in relationship to the assignments that the sub-entity identifies for staff? So clear lines of authority as another one of the governance principles or values that has framed the board's work in this area. Impartial, consistent, and fair decision making. This one is really important. Are the decision rules and precedents of the sub-entity documented? Are the bases for decisions documented, and are they transparent? Are professional standards used for decision making? And does the continuity of institutional knowledge reside in sub-entity members, staff, or both? Another really important principle here we find throughout the bar and throughout our sub-entity structure that often there is historical knowledge about decisions that have been made and why they've been made that reside with individual staff members, that reside with individual committee or commission or sub-entity volunteer members, but do not reside on paper in a way that is transparent and replicable going forward. And that is an important value that the board has used to determine whether or not any changes are needed to the sub-entity structures. The last governance principle, engagement. Is the public well informed about the services that are being provided? Are bar licensees and other stakeholders aware of the scope and nature of the bar's work in any particular area? Are opportunities for participating in improvement of any particular area understood and acted upon? And does the bar successfully avoid conflicts of interest or perceptions of conflicts of interest by guarding against being captured by those that it regulates or funds? Certainly this is an issue that has come up on multiple occasions with respect to our Committee of Bar Examiners. And certainly there are issues that have been raised. I think you mentioned it, Professor Meeker, in a fairly negative way, but issues that have been raised about the close involvement of grantees in the decisions that are made about how these funds will be allocated. And certainly that is something that the board should consider as part of this overall engagement principle. So those again are the key overarching kind of governance principles, values, guidelines that the board took into account as it reviewed the work of all of the various sub-entities. In addition, there was some discussion about size, sub-entity size. Our largest sub-entity is the Access Commission at 26 members, the Legal Services Trust Fund Commission 21 members, and I believe our Council on Access and Fairness and our Committee of Bar Examiners at 19 members. Much research has been done on the optimal size of decision-making bodies, and that research indicates that 7 is the optimal size of a decision-making body. The board did adopt, as a policy matter, a standard size of 7 for all of its sub-entities, with, of course, the ability to adjust or modify that size based on the actual functions being performed by the committee. I think a really important point that was made was size should be determined by the purpose of the sub-entity, not politics or personalities. So size is certainly something that the board has taken into account as it's made decisions regarding various sub-entities. So again, those are the overall governance principles, and in addition to those, the board did take a look at size. So now I'm going to move on. Can you go to the next one? Sorry, Joe, I thought they were loaded all together.
Debbie, sorry, Leah, can I ask a question before we move on?
Sure.
It was discussed by you and by Sean before that the trustees consider their role to be one of a fiduciary. What part of the engagement and other materials that we just discussed deals with the issues related to the handling of IOLTA money, EAF money, and other grants? To what extent is it important to the bar that there be cash controls and that there be mechanisms in place to be certain that the funds end up in the right hands used for the right purpose?
So I think the idea behind the governance principles are this, that those fiduciary responsibilities vest with the Board of Trustees, and that to the extent that the board has established sub-entities, as it did with respect to the Trust Fund Commission, that there needs to be clarity about what functions have been delegated to the sub-entity, that those fiduciary responsibilities, the entirety of them, does reside with the board, and that good governance suggests that there should be a clear delineation of which of those responsibilities has been delegated to the sub-entity. So, for example, the reports that have come to the board from the commission, we've gone back and looked at them for multiple years, including the 2014 reports that you referenced, Corey. These are very high-level reports on the total overall allocation level. These are not reports on the use of the funds. They're not reports on individual grant awards that have been made. But there is nothing written down that specifies that the board will only review the highest level total overall allocation, whereas the commission has been delegated the responsibility to make all other decisions. So that's, I think, the relationship between this concept of clear lines of authority and roles, and why it's important that that all be delineated.
All right, well, just to be clear on this, when I've made my reports for the last 3 years, every grant has been listed and put in a package for the Board of Trustees to review. So every grantee is identified, the amount of money they are receiving is included, and I've never had questions about it. And the second issue I want to make very clear, because you will hear this from me as the day progresses. Any change in decision-making that puts those funds at risk, in my view, is not passing the litmus test necessary for fiduciary duties to be exercised. If we make changes, and I'm not suggesting we shouldn't, but if we do make changes, the first order of business will be, does this put these funds at risk? In other words, is oversight sufficient to be certain that when a grant is made, the funds are used for the identified purpose? And if oversight can't be exercised by the decision-making authority, then we have a fiduciary duty issue. And to me, no changes could possibly be supported by me if it puts those funds at risk.
If I can ask, it was just mentioned in passing that issues have been raised about grantees' participation in commission activities, and I'm not really sure what that means or who raised what issues. The grantees do not get a say in distributions except as members of the public, and that they can participate in that respect. And of course they interact with staff when it comes to figuring out qualified expenditures and so on. So I'm really not sure what you were referring to.
Well, perhaps we can get into that when we move into the functional review, or we talk about the composition of the commission itself. But certainly comments have been made, and I would say by unsuccessful applicants, for example, that there is a very close relationship, appearance of a close relationship between the commission and existing grantees. I have heard those comments. I don't know that they have merit or not, but what I do know is that there is there may be some perception issues that need to be addressed. But what I'd like to do is to finish going through this.
And that's fine if I just say, but it was the commission versus staff, because that sort of surprises me in that I think staff have a much closer relationship with the grantees and interact with them much more than the commission, which, but it was the comments that you heard from some unnamed source at some point is referred specifically to the commission, not to staff.
Well, I think you raised a great point, because I know when we've been talking about a conflict of interest policy being developed, some staff comments have been, well, I think it would be helpful for us to have one that applied to us as well, because acknowledging that there are close relationships with the community, even among our staff. So I think that's a fair point. And I have heard that as well internally from my own staff. Yes.
Before you go on, Can you either tell us where we can find these slides on the web or provide copies of them to us?
Yes, I can. I know that my assistant has emailed them to the members that are participating by phone, but she didn't email them to all of the members, so we'll definitely do that. They are also posted as corresponding to the board agenda items, the Board of Trustee agenda items that they attach to, but that's not particularly helpful to you. So what I wanted to do next is just show you another PowerPoint very quickly that displays how these governance principles were applied with respect to various state bar sub-entities. Again, to give a contextual sense of the work, to emphasize the fact that the work has not been limited to looking at the Trust Fund Commission. So here you have the Commission on Access to Justice. You see the challenges that were identified with respect to the various governance areas and some of the questions that were put to the board. Next, we have the Council on Access and Fairness. I misrepresented that size. It is 25 members. So there, again, challenges that were identified and questions presented to the board. The Board of Legal Specialization, size and engagement identified as the challenges. And then a number of slides here that I'm not going to go into, but ultimately future directions, including outsourcing legal specialization or eliminating it altogether, things that the board considered with respect to that sub-entity.
Is the board considering, because there's several entities here which are now leaving the bar, is the board considering whether the IOLTA program should leave the bar? Has that discussion taken place?
No, so I don't know about the several. The Commission on Access to Justice, through that working group process, they voted and determined that the Access Commission should transition from the bar. The only other sub-entity or component of a sub-entity, which is really a program that is transitioning pursuant to the Appendix I process, is the voluntary portion of the Lawyer Assistance Program. That's our substance abuse treatment program. So I'm not sure what you mean by a number of these, but the Trust Fund Commission, no, that was not contemplated. Certainly that could be a recommendation of this working group, absolutely. So here's the Trust Fund Commission, 21 members. The challenges that were identified were the board size, role definition, clear lines of authority, and just a couple of explanatory slides that were provided as to what the Trust Fund Commission does. And the board did hear comment from Richard Schaffler, the staff to this assignment, that even in the formula-driven even under that formula-driven category, there are a number of policy decisions that are being made that are not coming to the board. And so when we get to the functional matrix, you'll see how we've attempted to handle that. So here were the initial thoughts presented to the Board of Trustees as to what the recommendations would be with respect to the commission. This, of course, all changed. We didn't ultimately bring any final recommendations forward to the board in September, but instead embarked on this stakeholder process. So the last one I want to show you before we go to the matrix, can you go to the last PowerPoint, Joe? I'm sorry, these are not all put together, but again, I'm just using the original PowerPoints.
Debbie, on that, the last slide before we concluded that presentation, that the initial recommendation was that the commission be eliminated.
Eliminate the commission and have the board set policy, staff implement. So this last one I'm providing to you because it gives you great detail about the Committee of Bar Examiners, and it's a functional analysis, which is exactly what we are proposing to undertake today and will likely continue to our next meeting. So again, I wanted to provide this context to say the overall framework for the review of the sub-entity is part of the more comprehensive review that the board has undertaken of the entirety of the bar structure. And as we begin to do a functional analysis of the Legal Services Trust Fund Commission, staff, and the board, we really modeled it in large part on a very similar functional analysis done for the Committee of Bar Examiners. So this is not, we are not going to go through any detail, but this is a very hard to read, but on the left you see the functions having to do with licensing, the current who's doing what, is a change proposed. Here we have also law school involvement, and perhaps it might make sense for us as we move along in our matrix development to add a column for grantee community involvement, because that's a similar paradigm may be warranted where we're very explicitly clear about how and when the grantee community weighs in. And then the last column is the Board of Trustees' role. So the functional analysis of the Committee Bar Examiner is quite extensive, as I think this one is as well. And just providing this to say there's a model for it. We, again, are not singling out the Trust Fund Commission, and this is a very similar type of process to that undertaken for all of our sub-entities, with the functional component being most specifically aligned to that recently undertaken for the Committee of Bar Examiners. And with that, I think I'm done here, and we certainly don't need to go through all of that. I think we had one handout that maybe Duan was going to quickly walk us through in terms of just the different funding sources, and then go into the matrix, if that makes sense.
This is Chris Schreiber. Can I ask a question? Leah, you mentioned that the bar had studied optimal sizes and had arrived at a conclusion that there was an optimal size of 7.
I can provide those citations for you. There's actually, I believe that it's the University of Pennsylvania, which has a really fascinating graduate program in governance. And so through that, we identified a number of works on optimal sizes of groups for decision making. And I can certainly provide a bibliography of that. I don't have that with me or on the top of my head. But that is an action that the board has already taken. I think the issue with respect to the Trust Fund Commission would be, again, is there a reason why the group would be bigger than 7? I do know that the board determined that the Council on Access and Fairness would be 10, based on the desire to have broad representation on that council. The Committee of Bar Examiners, 9. So there certainly, the Jenny Commission will continue to be, I believe, 38 people. So there's certainly room to make the case for a committee larger than 7. The Client Security Fund Commission, on the other hand, has gone down to 5 members. So I think the main point is it's based on the functions being performed by the sub-entity, and that's the really important driver of how large it should be, as well as the type of representation that you want on the sub-entities. So for a Council on Access and Fairness, not performing a function so much as wanting to make sure there's a diverse array of folks represented.
And I have one other question. You showed us the functional matrix for the Committee on Bar Examiners. For each of the sub-entities that the bar has reviewed, has a functional matrix been done?
No, because there are many of our sub-entities are not decision-making bodies. They're not acting bodies. They are policy advisory bodies. So where you're a policy advisory body, there is not a lack of clarity about who does what, because you make recommendations, you don't act upon them. The Legal Services Trust Fund Commission, the Committee of Bar Examiners, very clearly acting bodies, grant making or licensing. So there are different types of entities. The Client Security Fund Commission, yes, functional analysis was done. They obviously make decisions about claims to the Client Security Fund. So again, whether or not there was a functional analysis done, really driven by the functions being performed by the sub-entity.
So,
Margie
if I
Estrada.
understand your response, then there was not a functional analysis done for the Access to Justice Commission.
No, the Access Commission is a policy body.
I have a
I'm
number
not
of
sure
comments.
that Chris Schreiber was cut off. Chris, did you have any further comment?
Well, I was just going to ask a question about the comparison and its relevance, or maybe just make a comment that it does strike me that there is a difference between the bar and other regulatory agencies insofar as the bar's function is more closely aligned with one of the three co-equal branches of government. And so I guess that particular slide sort of catches in my throat because of the role of lawyers within the judiciary and within the judicial branch seems to me to be just sort of fundamentally, foundationally different than the veterinary board. So I just put that out there for the group.
Professor Meeker.
Yeah, I want to second that in terms of the flawed methodology and the comparison of the groups they had. All of those groups, the only thing they share in common is a regulatory licensing process. But the Nursing Association, the Dental Association, the Veterinarian Association, they don't have anything like the Access to Justice Commission. Nobody's saying the access to veterinarians for the poor, for example. They don't have anything like that. And in addition, none of them have anything similar to the Legal Services Trust Fund Commission. The Nursing Association, the Dental Association, the Veterinarian Association, they're not handing out money for provision of these services for the poor in California. Also, I'd like to point out that size mattered. There's a very narrow literature that they looked at, which I don't think is applicable for either the Legal Services Trust Fund Commission or the Access to Justice Commission, or the Commission on Access to Justice. For example, the Access to Justice Commission was formed on the basis of the original and Justice for All report that was started back in '95. If you look at that, the whole idea of that commission was to have members from a broad variety of different groups represented, all the way from the Women's League of Voters to the bar to the judiciary. The idea was to have breadth. And if you look at some of the major works done by that commission, if you look at the language access, that couldn't have been done with just 7 people. That wouldn't have the level of expertise to do that. If you look at the issue of access to justice in the rural areas, you can't find just 7 people out there with the level of expertise to write that. It needs a broad base of different expertise in order to do what it does. And I think the same thing is true with the Legal Services Trust Fund Commission. So I'm not persuaded by this analysis by Mr. Shuffler at all. And I hope after the presentation of what the Reboot Committee is, everybody realizes his conclusion that the Reboot Committee was basically grantees determining what data is appropriate for their grant allocation is completely false. That is not what that committee does. And he was corrected on a number of occasions, and yet he persisted in maintaining that false presentation of that subcommittee.
Okay, I thought I heard Margie on the phone. Did you want to?
Thank you. I am speaking as a public member right now, and I wanted to just make a couple of comments. One, I wanted to thank everyone on the commission for, your very hard and good work that you've done throughout the years. And I also wanted to highlight that no one has ever come to my office and complained about not receiving grants or complained about conflicts of interest in having folks who serve on the commission, serve on boards of legal aid organizations. And I wanted to also just highlight
Carmen
that
Chavez, Casa Cornelia Law Center.
Has left the conference.
I also wanted to highlight that I personally think it's very important for people who are engaged in decision making around legal services for the poor to have something to do with that. It is a wonderful thing that people who are on the commission, who are lawyers, are willing to, take their time, which is super, because I know it's tough to be practicing law, to take that time and serve on boards, etc., and to say, or to suggest that a person, because they're serving on one of these great boards of a grantee organization, is not a good person to have serving in the capacity of making recommendations of who should get grants. I just don't agree with that. Actually feel of that, which is that gives them that puts them in a better position to make recommendations. And I don't think that those types of people are the types of people who generally are biased and would just naturally be, let me get some money over to this organization. That hasn't been my experience in folks who serve on those types of boards. So I just wanted to put that on the record.
Thank you.
Okay, hold on.
Can I just
Hold on.
ask one question of Leah, just as to the study about size? Was the study done of any organizations that had to comply with Bagley-Keene? It's been my experience in trying to organize meetings of the commission and otherwise that Bagley-Keene has put some pressure on attendance. And in many instances, the search for quorum was difficult. And that seems to have been made more difficult since Bagley-Keene. I don't know if any of you who are on commissions or committees who've had to deal with this problem understand what I'm asking, but any studies that were done prior to Bagley-Keene, it seems to me, aren't relevant for California because we have a specific problem in making quorum.
Right. So I think it was a separate point, not part of the studies, but increased size, this is just a note from this slide presentation, makes meetings with full attendance difficult, if not impossible, to the point of failing to create a quorum requiring additional meetings. So not part of the research studied per se, but an observation across many of our sub-entities when we look at attendance issues, that the larger the sub-entities are, the more challenging the quorum issues are. So that's something kind of easy, quote, put that in quotes, for us to track, looking at attendance records from meetings based on the sizes of the sub-entities.
Sean, are you on the phone?
I am, thank you. So, Rich, I just wanted to circle back to you. You made a statement a little while ago about changes that would place the IOLTA funds at risk. And I just want to clarify what you mean, because in terms of standard financial controls, the funds are currently handled by State Bar staff in the usual manner and subject to audit and so on and so forth. So I think you're referring to the Commission's work in looking at what grantees are actually doing with the money, not some sort of internal financial control issue for the State Bar. Am I right about that?
Not entirely. It seems to me that one of the roles of the commission has been to observe the relationship between staff and grantee. If there's an opportunity for abuse, you have to see every intersection at which abuse might occur, and that is one of the intersections where it might occur. So I agree with the point generally that we are concerned about the ultimate use of the money once in the hand of grantees, but getting it into the hands of grantees in an appropriate manner, it seems to me, is part of an oversight function. And the question that's posed to us is, who's best positioned to exercise the oversight at the intersection of staff and grantee, Board of Trustees or the Commission?
What kind of abuse by staff are you thinking about here?
You know, I want to be very clear that I can't give you an example of this having occurred in my many years of experience with the Commission, so I'm not drawing on any firsthand experience. But I do know that the opportunity for abuse that occurs between grant maker and grantee is something that private foundations and other grant makers are always concerned about. And the proximity of staff to grantees is a point of intersection that needs to have oversight. So the question I put to all of us is, who best is able to exercise the oversight at that intersection point? Board of Trustees or the Commission? Professor Judge.
So I guess my reaction is I'd like to sharpen that up. Hold on, I'd like you just to sharpen that up because I think it's a very serious sort of allegation or risk that you've raised, but it's really quite unclear to me what exactly it is and how it should be addressed. So just give that some further thought for later. I'm sorry, Judge Seligman, I think I spoke over you. I apologize for that.
No problem. I just got elevated from professor to judge. I guess that's I have done that before.
Are you certain that's an elevation?
Yeah, you're right. Actually, I devolved, not evolved. I just had a point of clarification, which is the discussion about the size of the commission. It's not clear to me, and maybe someone, is that actually within the purview of one of the matters we're supposed to be addressing here? Because if it is, that is an important discussion. Is that something that the board is considering right now? So it's really just, is that something that we should be having in our file here going forward?
So the way that we handled this with other sub-entities is the board adopted a set of global recommendations, size being one of them, the elimination of nominating committees. There were a host of global recommendations that applied to all sub-entities. In each instance, the particular sub-entity had the opportunity to weigh in on the recommendation and provide its feedback to the board. The Trust Fund Commission has not been able to do that. And I'm not exactly sure. I think I asked staff when the next meeting of the Trust Fund Commission is, and has it not been set, or it's in March?
It's getting scheduled right now for the end of January will be the first one.
Okay, so.
So it hasn't happened yet.
No, it has not happened, and the commission would have the opportunity to weigh in, and then that comment or feedback would be provided to the board, because all of these other sub-entities have been able to do that.
I appreciate that clarification. One other thing, though, which connects to this, at least last I heard, we have a lot of vacancies that aren't being filled on our commission at this point. Is that still true? Was there a freeze on appointments?
The board did freeze most, or if not all, appointments pending the completion of the Appendix I review for all sub-entities. And so I'm not intimately familiar with the appointments process for the Trust Fund Commission specifically, but that was an action that was taken maybe a year ago or more as the Appendix I process was underway, and it became clear that there would potentially be recommendations to eliminate sub-entities or modify the size. So again, I'm not.
The only reason I raise that is if we're supposed to consider size in January, I'm wondering, is there going to be, how many of us are actually going to be here to have that discussion? Because I know we've lost a bunch of people recently, and no one's getting appointed. It's a concern I have.
We've also lost one of, we are down to one client member, should be said. So the voice of legal services clients has been really diminished on the commission since that seat can't be filled. Also, I just like to point out that the state bar does not make all of the appointments to the commission. So, although I'm a little dubious of the idea that 7 is a magic number that works regardless of what an entity is doing, and I think from a practical perspective, the commission would not be able to function at that size. Aside from that, there are, I believe, 7 members of the commission that are appointed from the judicial branch, and so the state bar cannot eliminate those seats. So if they want 7 members, they would have to eliminate all of the seats appointed by the state bar.
That's actually not accurate.
No? Okay. So
Do you
how
want to
many?
speak to that, Brenda? But it's the board created the Legal Services Trust Fund Commission. So.
And Bonnie is here.
Well, I'd like
listen.
to have our general counsel speak to that question. Thanks.
I'm not intimately familiar either with the exact appointment process, but as a general matter, when the State Bar has created a board, for instance, when it created the Access to Justice Committee, by the mere fact of delegating appointment authority to other agencies or the judicial branch, for instance, that does not amount to granting the judicial branch the authority to maintain those seats.
Bonnie, if you'd come forward and access a mic, I think it'd be helpful to people on the phone.
And perhaps you
Bon-
could tell people
Um,
your role so that people know who you are.
I'm Bonnie Huff, and I'm staff to the Judicial Council working on the Equal Access Fund. And as part of the Judicial Council's responsibility for the Equal Access Fund, it, at its August 1999 meeting, established that there would be 7 voting members of the Legal Services Trust Fund Commission and 3 non-voting judicial members. Judge Seligman is one of those non-judicial voting members. So I don't know, but that's part of our contractual relationship for the administration of the Equal Access Fund. So
Okay, so
something
that's
to
part of
consider.
the annual contract with EAF.
Yes. And it is, we would have to go back to the Judicial Council, which, but that is just, so it's not, yes.
We can look into the mechanics of how the foundational documents and the contractual relationships
Okay, so I think we're,
intermesh.
Dawn, I think it's your turn now.
Joe, are you having, did it disappear, the chart?
I'm going to recommend that after Dwan makes her presentation, we take a break.
And I'll be short. So our office put together this chart with the help of Brady, and it outlines kind of the funding streams that come into our office for the administration of the legal aid grants, and then the authorities for distribution. The IOLTA revenue is obviously from the Business and Professions Code, which we talked about at length, by IOLTA formula. The licensing fee opt-out, that's the $40 opt-out. That's also from sections of the Business and Professions Code, which allows the State Bar to distribute the licensing fee through, we roll it into the IOLTA grants. The same with the Justice Gap donations opt-in, that's $100. The Cypre and any other kind of donations that we receive from the Justice Gap funds, those get pulled into IOLTA and gets distributed through the IOLTA formula. The Cypre, it's not the Business Professions Code, that's California Code of Civil Procedure. Then we have also tax intercept funds. These are funds from attorneys that have committed malpractice. And we receive a portion of this from the California also Business Professions Code, and that funding also gets rolled into IOLTA grants. And then the next 2 lines are the EF grants, Equal Access General Funds and the Equal Access filing fees. So as you'll recall, the total of these 2 line items, 90% of that goes out through the EAF grants, and the other 10% goes out through partnership grants, and that's through the annual budget legislation language. And then the bank settlement awards, that's our latest discretionary grants, and we rely on the bank settlement agreement to determine kind of the parameters for those grant awards. And generally speaking, they must go out to fund projects that engage in foreclosure prevention, legal assistance, and community development legal assistance. So keep this in mind when we switch gears and talk about the matrix.
Dwan, off the top of your head in round numbers, last year's 2018 contribution from each of those line items, or the major line items?
Yes, those are the major. So the major buckets are IOLTA, EF, partnership grants, and bank grants. So the first from IOLTA down through tax intercept funds, that's all IOLTA.
That was about 14 million, 15 million?
I think yeah, I believe so. And then
The
this coming
EAF
years.
grants were about 23,
Mhm.
right? And
Yes.
the non-recurring, the bank settlement awards.
For about $8 or $9 million last year, I believe. And you have another spreadsheet from one of the former meetings that breaks that all out in detail.
Thank you.
Thanks. Are there any questions? No? Okay.
Margie Estrada is a member of the public.
Has left the conference. Has left the conference.
Let's take a half hour for lunch and bio break.
Actually, we probably should do a working lunch, huh?
Greg Fortescue?
Has left the conference.
Half hour for what? Is that enough?
Has left the conference.
Hello to
Has
everyone.
left the conference.
We still have so much to do. If I can have everyone's attention for a minute, I think we're going to try to do more of a working lunch. So let's do.
Margie Estrada is a public participant.
So we're going to try to
Has
take.
joined the
try to be back
conference.
in like 15, 20 minutes. Okay. Thank you. 20 minutes, 15, 20. If we do 20, we'll probably be good. We'd like to start. We'd like to start.
Yeah, I just meant I need more than I need to have an hour.
Margie Estrada as a public participant.
Has left the conference.
Jack Daly, Legal Aid Society of San Diego.
Has left the conference. has joined the conference. has joined the conference.
We're about to recommence at section 2D of the agenda. I want to make an announcement in advance that we expect a visitor here at 1:30 to make a brief presentation. So we'll take a break then. We'll go through the matrix and finish hopefully by 2:30. Those of you who have reserved comment would be welcome at that point. And I don't believe we'll have enough time to get through the matrix. And as a result, I would expect that it will form part of the agenda for the January 9th meeting that'll be scheduled for San Francisco.
Has joined the conference.
Yeah, I have a question, a request if we can. I'd like to go back to the discussion of the vacancies on the Legal Services Trust Fund Commission and whether we can go back and comment on that. I think it's a significant problem, and if we could address it, we don't need to do it now, but when there's time.
All right, let's reserve that for about 2:30 after we finish discussing the matrix.
Okay, thank you.
Okay, so let's just walk through this. To start, I'll just provide just a brief sort of overview of the structure. It is organized by the various funding streams, and so going back to the information Dwan provided before we broke for lunch, we have the IOLTA, Equal Access, Justice Gap, and licensee fee statement funding sort of all lumped together because that's all going out on the IOLTA formula. And then you have the partnership grants, which is that 10%, I believe, of the equal access funding, and then the bank grants. So this is separated by funding source. And then you have kind of the key functions that staff have identified are being performed.
Has joined the conference.
The current staff role and the current commission role, the proposed staff role and the proposed commission role. Those proposals reflect staff's proposals, with staff, myself included. Change from current. Is this a change, yes or no, with respect to the proposed roles of staff in the commission? And then there's an attempt to identify whether the function itself is a policy function or an administrative one. And you'll see a theme throughout this document of trying to reserve to, certainly to the board, but also to the commission, primarily policy work, with most of the administrative functions being performed by staff. And then in the far right columns, you see the current role of the board and then the proposed role of the board. So hopefully that's fairly self-explanatory. I did go through this earlier and see that there are a couple of errors in it. We don't get there till the third page, so I'm not sure that we're even going to get to the third page today. But if we do, I will point them out. So the first is development of policy, guidelines, and statutory changes, any that are promulgated. Before we get into it, could Dwan or Rocio just talk very briefly about what we do have? We have state bar rules, we have guidelines, which I've reviewed both of those. We obviously have a statute. Are there other kind of governing documents that inform how you do your work besides the rules and the guidelines?
And there are one-off kind of policies and guidelines that will occasionally be brought to the commission for approval. So they live not in a single document, but sometimes can be found in the minutes to the commission meetings, and sometimes we pull that and include it in an internal document. Staff also has what's called sticky meeting issues, where we talk about kind of some of the gray areas of determination, and that to us is like a guideline of how to deal with a certain sticky issues, gray areas. Some of that gets elevated to the commission when it presents itself in an application, and a lot of times it doesn't present itself. So I think that is probably a place where at some point those guidelines may be codified into policies at either in the guidelines or in the state bar rules.
So the recommendation here is that staff would propose any rule and guideline changes. Those would be worked up by staff. That they would identify, I think, in a more structured way, the sticky issues or the gray area issues to bring to the commission for review. That then the commission would approve any rule and guideline changes proposed, and in addition, address any sort of new guidelines or rules or procedures that would need to be developed to codify decisions that have been made about the gray areas. And is that a change from our current practice? Yes. And then as we move over, we see that the board's role would be to approve rule and guideline changes. Right now, the board is approving rule changes. The guidelines, to my knowledge, have not come to the board. It's sort of unclear. We can't find consistent documentation on the guidelines going to the board. So that is the proposal there in row 1. Well, I think as Dwan mentioned, there are, maybe you can explain.
I can clarify. With staff, we don't have a lot of guidance in terms of what clearly should go to the commission and what clearly shouldn't go to the commission, and it's the staff determination. So every year, whenever there are issues that arise, staff, we meet as a group to make those determinations, but it is a judgment call. We don't have bright line rules. So I think there have been inconsistencies from year to year, from groupings of staff to staff, is what we've noticed. So if there can be kind of a list or the bright line rules where these are all the instances that staff need to elevate to the commission or the board of trustees, whatever gets decided, that would be helpful. I think we have a sense, but there are, even amongst us, sometimes disagreements of whether what gets elevated. And you know, we have, I think we veered on being
Has joined the conference.
more inclusive, but sometimes it may not be necessary.
So this is primarily disagreements among the staff. Should it go to the commission? Have you ever had a situation where you went to the commission said no?
Like, what you mean, the staff's recommendation and the commission has disagreed?
No, where the commission refused to consider it, to either agree or disagree.
I don't think the commission has ever refused to entertain something that we brought up before them. But there have been instances that I can sense that maybe the commission thought that it wasn't warranted a discussion, that maybe it could have been decided at the staff level. That's more rare, but it has come up in my experience.
Dwan, just to be clear about what staff means by policies, guidelines, so rule and statutory changes already go before the Board of Trustees, so that's not an issue. So when I think about commission policies, we have certain written policies that have been developed, for instance, about a recent one was board member participation in in-person visits. So that's one of the things I assume that's being called a policy. Is that right? And that's a written document that was voted upon by the commission with public comment. And then, so when you're talking about guidelines, in contrast, you're talking about informal stuff.
They're both the formal guidelines. There's two sets: the one for qualified legal services projects, and the one for support centers. So those are like kind of the formal guidelines that
the application. You're talking about application guidelines.
Yes.
Okay.
And then there's also like in our office, what we call guidelines. We don't call them policy documents. We call them guidelines because they're guidelines. They're not totally prescriptive, but they help us in our analysis.
So I think the general idea that perhaps more could be codified about what needs to be elevated to the commission and what can be handled by staff is a good idea. There are some areas where staff is already working on proposals for that. As for the application guidelines, I think that the Board of Trustees should consider, do they really want all of that to come to them? That would be fairly time intensive, I presume, if there's any kind of changes. Also, I mean, I kind of hate to raise this because it might cause a headache, but it may be that one of the issues here is what actually requires a public rulemaking and what doesn't. as I've said, everything that needs a rulemaking needs to go to the Board of Trustees, and I don't know that the bar has had a general counsel opinion on what documents might require a rulemaking, but it seems like there is existing law out there about what kind of thing is a rulemaking and what isn't, and then maybe there are things that are rulemakings that need public comment. And those are the kind of things that the Board of Trustees would be interested in. And then it wouldn't require this parsing between what is an application versus, what is a guideline versus what is a rulemaking.
And as far as the
Just a
guidelines,
thought.
maybe Selena can speak a little bit more to it, but my sense is that, like Leah was saying, we couldn't find documentation of whether the guidelines were, say, voted on by the Board of Trustees or were sent out for public comment. But my sense is the legal aid community would like, if there are changes to our formal guidelines, that would be sent out to public comment.
Mm-hmm.
Justice Ray.
Yes, I would agree with that.
I gather the point of this exercise is to break down all of the various functions performed by the staff, the commission, and the Board of Trustees, and then to allocate the responsibility for doing this. So I'm not sure that there's a need to make this judgment as to whether something is a guideline or whether formal rulemaking is necessary. I wouldn't think. The point is that you do have things that are called guidelines. Well, maybe they're not even called guidelines, but they're informal rules that guide the actions of staff and may also guide the actions of the commission. And these are done, and the question is whether or not the board should have a role to play in those in terms of finally approving them. Is that what we're talking about?
And I think because our state bar rules, the guidelines are called, the documents that are called guidelines look like this. And they are guidelines that include both guidelines and commentary, which serve to elaborate on the rule. And so because they are, I've done this exercise of reading the statute side by side with the rule and then the guidelines, and they really do all work together in terms of how we are interpreting the statute to actually get it into something concrete that can be implemented. And because of that, in my view, the guidelines do, at least these guidelines, do lend themselves, they fall more on the policy side.
Okay.
Yeah.
Well, then in that case, that seems perfectly appropriate. But Corey raises a point, and I was wondering about this during the earlier discussion. I don't have a clear sense of all of the things that the board has to do, and whether it has time to do the things that we may ultimately decide. Well, we won't decide anything, but one might ultimately believe the board should do at the end of this whole process. Does the board have time to do it? And I quickly resolved it in my own mind by simply saying, well, the board can decide for itself whether it has the time to do it. So we don't need to go through that sort of grueling process to decide for the board whether it has time to do what we're suggesting it ought to do. But that's my comment.
It's been my experience that grant guidelines have been, as a matter of policy, when changes to those grant guidelines have been recommended by staff, that these have requests for change have been brought to the commission, and the commission has voted on them. When it involves a rule change, considerably different than a grant guideline, all rule changes have not been approved by the commission, but rather recommended by the commission for approval to the Board of Trustees, and historically brought to the Board of Trustees. So there is a significant difference between a grant guideline and a regulation or rule. And certainly there would be even greater difference if it involved a statutory change. So
well, you're saying there's a difference under current
that's correct.
Policies and,
right.
But I thought one of the things we're going to consider, I'll put it that way, is whether that ought to change.
Right.
I mean, we talked about the board's abdication of responsibility over a huge swath of area here. And if you're of a mind that the board ought to assume greater responsibility, then it does make sense to sort of identify all of the multitude of decisions that are made by the commission, the board, and the staff, and place some responsibility for those that ought to go to the board. And I don't know that, I think that's kind of a progressive thought in a way, that even guidelines that ordinarily are akin to what we used to call underground regulations, in that they do determine outcomes, but they're never voted on by anyone other than, in some cases, it's just staff decides.
Right.
That's how it's going to be. The idea of putting that before the board for a vote seems to me to be a perfectly progressive idea. I appreciate it may not be the way it's done now, but we've been lamenting, or some of us, I wouldn't say us, some people have been lamenting the lack of board involvement in all of these things, and this is as a way to get the board involved in a way that they cannot and impose responsibilities that they cannot shirk. They will have to consider these things, and that might be a good thing.
I think it's just a matter of where to slice it. Justice Ray, which I think probably can't, as Your Honor mentioned, can't probably be decided without some discussion by the Board of Trustees themselves, because I think there is a difference between grant application guidelines and, for instance, a written policy about commissioners going to, the once every 3-year meetings.
On site.
And I can see the board having a lot more interest in one than in the other, and so there I think the board will have to think about how much detail it wants.
Yeah, what you're saying, though, is that not all guidelines are created equal, and some of them the board might want to have a say, and some perhaps not. But the idea of putting them all on the table for consideration by the board makes sense to me. And while I'm still talking, and I'll stop in just a minute, it also seems to me that what's sort of odd about this arrangement is that you have a commission, a rather large commission, and I agree with the sentiment that large is not necessarily a bad thing, but it's just sort of odd that you have a commission the size of this one that has more than an advisory role. I mean, there are all sorts of advisory commissions. That's how you involve the public in the workings of an agency. You have a commission, or whatever you want to call it, that has an advisory role, but this is a commission that has really has sort of a governance role. And this the reboot committee, which I regard very favorably myself. I thought that was a good thing, but nevertheless, there's an intimacy there between the commission and staff in making what amounts to policy, or considering policies anyway. And that just, for some reason, just sort of strikes me as sort of odd. When you have such a close connection between staff and an advisory commission, that they sort of, there's a little coloration of staff and advisory commission in the membership. So,
Judge Sullivan.
Yeah, I think the question about guidelines, what strikes me is there's a definitional problem here, because we use the word guidelines to cover everything from how the staff interprets a financial filing. We have a guideline. We look at, what do we consider administrative work or whatnot, to matters of, when I'm looking at a particular applicant where we have where staff and/or the commission has some concerns about whether they are fully complying with the grants, some practice about looking at, it's like, is it a practice, is it a guideline, is it a case specific, is it a broader policy? I think that's the question. I think anything that touches on broader policies, I would agree with the justice that clearly is something that the Board of Trustees should decide if they want to get involved in that, and it would be appropriate for them. But I'm concerned that this term guidelines could sweep so broadly that you're going to be dealing with the day-to-day stuff, which doesn't deal with the general policy, but deals with the practical realities that any staff, any committee, any group deals with on an everyday. And it's not so much underground regulations. We're not saying this is legal services work and this is not. That clearly is something that should be elevated. It's a much more, some of this stuff is sort of the minutia of daily life.
But don't you think that would all?
There needs to be a clear definition.
I'm sorry. Don't you think that would all come out in the wash? I mean, when you're dealing with it, but at this level, when we're talking conceptually, I would not want us to to develop these hard and fast categories and rules to describe them. I would leave that for some kind of practical application of what some people call common sense, even, and doing that. But anyway.
Well, one of the problems that I have is that those of you who have been on the commission, perhaps those of you who are in the inside of the state bar know this, but I don't fully what is a guideline. So if I vote to have this first line on the chart be accepted as the recommendation of this group, what have I voted for? I mean, to say there are informal guidelines and then there are some that are written down, I get the ones that are written down, right? But I don't understand the content of what seems to be many, many guidelines that the staff uses to make decisions about applications for IOLTA and EAF funding. So unless I understand that, it's really hard for me to say that I agree with this line on the chart, right? So I think to Judge Seligman's point, some definition for purposes of this exercise of what we consider to be a guideline that would have to go to the board for approval after going through staff and the commission and whatnot is pretty important, at least to me, so that I can understand what I'm recommending be the new practice.
So I think just in the interest of time, we can certainly take that back as a staff team and try to define it. Certainly it would be the published eligibility guidelines. I think we can start there. And then we can go back, because I think the point is well taken. If it's purely administrative, and that's kind of the overall construct that we're working with, purely administrative things would not go to the board. So I think it's that distinction, and I can work with staff, for the next meeting to be able to better define that. So this is sort of qualified agreement in concept with this approach, but more work needed to define exactly what guidelines are. That's the way I'm understanding it.
This is Rich. I want to make it clear that this matrix conversation, well, I think it's very worthwhile, and I encourage that we go through it in its entirety, is confining. There are, within the four walls of this matrix, no alternatives. The alternatives are either yes or no. And that, to me, is too limiting. Initially, my thought was that we would do a traditional SWOT analysis of the existing procedures where we would examine strengths, weaknesses, opportunities, and threats of the existing grant-making process, and once that analysis was complete, make recommendations for change. Then this morning you might have recalled that I made mention of the fact that perhaps the thing we ought to do is to examine what would be the ideal way for grant-making to be undertaken, given consideration of all of the functions that are involved in the various constituents. Here we have in front of us a matrix that is very confining. It doesn't do either of those things. It doesn't analyze the past, and it doesn't give us a tabula rasa on which to write the ideal method of grant making. Good.
I think we've had weeks of tabula rasa.
And we haven't gone very far.
And this is what is so great about that.
Turn the mic on.
We wouldn't know what we're talking about. There may be disagreement around the edges.
I guess I ought to turn this on. The other point I wanted to make was, one of the columns is policy, and this is to your point, Margaret. One of the columns is policy, and that is checked there. So we're talking about regulations and guidelines that have policy implications, right? And doesn't the board need to sign off on that?
Yes, and once you check the box that it's policy, you have to draw that conclusion. The question is the X correct? Is a guideline that tells you what sort of accounting is required policy?
Well, there's no way we could define that. It has to be on a case-by-case basis, doesn't it? We have to look at staff can call it whatever the staff wants to call it. But if in fact it's regulatory, if in fact it has policy implications to it, then it is what it is, no matter what label they put on it. And here we're saying that one of those things, whatever you call it, that has those policy implications, has to be approved by the board. And somehow, to me, that makes sense. Although I also agree with Leah that this is a point that we could talk to death all afternoon, and I don't know that we would reach agreement.
I think one of our participants wants to speak. Chris, is that you?
Yeah, this is Chris Schreiber. I just had a quick comment, and I'm afraid I have to run to a hearing in San Francisco Superior, so I'm going to miss the next stretch of the meeting. But I just wanted to make the point that perhaps will resonate with the judges and on the working group, which is simply that these are abstractions in many ways, and I guess I would ask the group to consider where an actual case or controversy has arisen that illustrates these points, if one has arisen. So if there's a way to demonstrate the difference using an actual example, then it seems to me we might be a little bit more grounded in how to take on a definition. And then if there isn't a case or controversy that we have experience with, I can appreciate the board's interest in having, a top-down understanding of this sort of clarity between a policy and a guideline and a clear governance structure, et cetera. But I would suggest that in the absence of any history of a problem, we might be spending too much time on something that is sort of less important than we think it is, or than we're giving it weight to.
So I think that would be part of when we come back with some sort of definition of a guideline from Leah and her staff. Perhaps some of those examples can be given to us at that time.
This is Greg Fortis.
Greg, go ahead.
Greg, hey, sorry, I was just going to make one. Go ahead. Sorry, Greg, one last thing before I jump off, which is it would be helpful if we could get the matrix or the work of the staff more in advance of the meeting. Just it's very difficult to consider the matrix and its content sort of on the fly and feel that it's as considered and deliberative as, at least for me, as I'd like it to be.
All right, Greg, you had a comment?
Yeah, I would agree with that, Chris, especially as we move towards the last meeting. I'll take, I guess, the opposite view of the matrix. I actually find it very helpful. This is what the board wants this stakeholder group to do, to look at the functions of the staff, to look at the functions of this commission and to help it improve its governance of the commission. The board is, as Justice Ray said, the board is going to sort these things out in the wash. If you decide that certain decisions are not policy related, they will decide whether or not that's true. And but I think what they're looking for is everyone's best thinking around some of these functions. And if we need to define what a guideline means in order to educate the board as to the types of decisions that this stakeholder group thinks that it should be the ultimate decider on, then we should come up with that definition and then put everything else in front of the board as well that this stakeholder group thinks doesn't really require board involvement. But I think that this actually organizes my thinking a bit. And Rich, I understand what you're saying, but I don't think we need to, at this point, reimagine the optimal way in which this grant-making function can work, because I don't think that's what the board is asking this group to do right now. What has become clear through this whole process is that the board's governance of this sub-entity, as well as others, needs to improve. And I think this is a very helpful way, for me at least, to really start unpacking what does the commission do, what does the staff do, and how can the board, what makes sense for the board to be involved in terms of the decision-making around certain policies or certain guidelines that implement rules that it approves.
This is Sean Saleg. So, my reaction to this is, I think Leah and her staff wrote this, so she can correct me if I'm wrong, but, I think the intention of item 1 on this matrix is to express the concept that policy decisions should be handled by
joined the conference.
The commission making a recommendation to the board, and that this semantic thing we've gotten into about what is a guideline, I think, is beside the point. If it's a substantive policy decision, whether it's called a rule or a guideline or whatever, I think that's the kind of thing that this, as I understand it, item 1 is proposing should go to the board for final, for consideration and final approval.
Other comments? Anyone else on the phone? Any of the members of the working group on the phone want to have a comment? All right.
All right, the next one, item 2, this is no changes being recommended here, but determining the total amount available for distribution annually. Currently, staff develops options and recommendations. The commission votes on staff identified options, and that ultimately does go to the board for approval. No changes being recommended here. Trying to identify which part of that process is policy versus administrative. I think that the policy question there is always how much to retain in reserve. That I see as a policy issue, whereas the determination of the actual dollar amount is more administrative. So not recommending any change to that particular function here.
Any questions or comments about that?
All right, so here's where we get into, I think, some of the meaty things. Review application and audits to determine eligibility. So right now, staff determines eligibility subject to final approval by the commission. And maybe, I don't know what would be the most helpful. I'm going to talk about primary purpose first. And Dwan, maybe you can describe right now the current process that staff and the commission use to determine primary purpose and what kinds of questions come up in that process.
So right now, when the IELTS and EF application comes through, staff does a first pass, and we work with the grantees to work out any kind of technical issues or if numbers are off. Any substantive issues is when we elevate to the commission for further determination. And during the application, first phase of application review, we determine whether a program has met primary purpose and whether their qualified expenditures are correct. And as you recall, primary purpose for QSP is whether their main function is to provide free legal services to indigent clients, and indigent is defined several ways in the statute. And for support centers, their primary function has to be to provide support legal services to the legal aid community. So that's kind of the first pass in terms of determining eligibility.
And as I understand it, because we're going to move into the next one, which is reviewing qualified expenditures. So they're separate determinations that are made. Is that correct?
There's separate
primary purpose, and then looking at the qualified expenditures, and then looking at, we'll get into whether or not legal services are being provided.
Exactly. So they're separate. There's two separate questions, but we do them concurrently in the application review process.
We do them concurrently, and then the commission deals with both at the same time, or the commission deals with them separately?
The commission deals with the issue, any issue related to qualified expenditures and primary purpose at the same time.
Okay. So with that, why don't we do primary purpose and then look at qualifying expenditures? So we're on two sides of the page, just printing sort of upside down. And Joe, yeah, if you could go down, we're in number 3. So right now, at the current process, staff determines eligibility for most programs subject to final commission approval. And what's being proposed is staff makes final determinations for all applications within established policy guidelines, and the commission makes the determination for all applications presenting novel issues or issues not clearly identified within established policy guidelines. So the change is a fairly modest change, but the change would be that the commission does not approve the determination of primary purpose, qualified expenditures, or the definition of legal services for every single application, but only those that are brought to it because they're novel issues, staff needs input, they don't know, they're not sure whether or not something falls within the established guidelines. And so through this proposed change, the commission again is dealing more on the policy side, staff is dealing more on the administrative side, and there's no current role of the board, and there's no proposed role of the board with respect to the review of individual applications.
I'm confused about what the change actually is on a practical sense. It sounds like the change would be that staff decide what kind of issues need elevation, whereas currently the discussion of whether something needs elevation is made with staff and the subcommittee working together. Am I understanding that correctly or not? Because I just don't see what the practical effect of this is.
I think the way it would work practically, and please jump in because this is not what I do every day, is the applications would come in, staff would review them, they could go in 2 piles. 1, approved, primary purpose, fine, qualified expenditures, fine, legal services, fine. And that would not come before the commission. And then there'd be another pile that would be either no or we don't know, and those would go before the commission.
So practically speaking, I think that already basically happens. It's just staff makes a recommendation to the commission as to the vast majority of these issues, and there's only really further discussion when something needs elevation and further discussion, right? And I'm not.
I think that's right. The only difference, I think, is what happens is staff brings us a list, and the list is, we think these all look fine, and these we have some issues on. And by giving us a list, it's not secret if any of us have questions about any of these, and sometimes we do. We look at it, I'm looking at the list, the numbers seem out of whack, or I've never heard of this organization, and it'll be a question of clarification or something like that. As a practical matter, the commission doesn't question or usually have a problem with the very vast majority of the recommendations of the staff. And you're right, it's the squeaky wheels where we spend our time. where the staff says, we got a problem here, or we need your help to figure that out. So I'm just worried about making a statement that essentially gives complete authority to the staff to make decisions without any potential for review. It's not that we spend a lot of time, but we have a fiduciary duty also on the commission. So I don't think it's a big difference, but the appearance gives me a little concern that there's a whole area, and there's several other places in the proposals, whole bunch of areas where the staff essentially is insulated from any review, even a question, as I see this written from the commission. And I don't know that it's necessary or it saves any time or accomplishes very much, except gives sort of a suggestion that there's a fenced-off area where the commission can't even ask questions.
I just want to say that I agree with that, because especially in light of your comments earlier about receiving complaints about the relationship between staff and grantees, it would seem to me that you would want to have a body reviewing decisions by staff that these applications are great. At least, as Judge Seligman says, looking over a list and pulling something off for discussion if there's a question.
Let me just make one other clarification. We do this every year, so staff may come in and say, we recommend grant on organization X, where there was a problem last year. And a completely appropriate question for a commission member is, well, what's changed? How come it's good now? I mean, those are the kinds of things that oversight that I think we need to do. It doesn't happen very often. I want to be clear. This is not, I think, as Corey pointed out, this is not a big difference. It's not a big problem because 95% of the time, there's no questions. It looks fine to us when there's a recommendation. But I think we need to have, I don't want to be in a position of saying, so accordingly, the only thing, instead of giving me a list of 120 entities, I'm going to give you a list of 3. I don't think that's appropriate oversight.
This is precisely the point I tried to make before. The oversight ball is being pushed left and right away from the commission. I appreciate the intent here. But I want to be very clear about this because Sean Seleg asked me this very question. The 3 items that are on this list will shove the oversight ball down the ladder. And by doing that, it will reduce oversight and increase the opportunity for abuse. As Judge Seligman just pointed out, I've been on this eligibility committee for a number of years. We see lists of everybody. And there are times when grant applications come in that are not approved. They don't raise gray areas. They're simply not approved, or amounts that are requested are not granted, lesser amounts are granted. And the hard questions by commissioners to staff on those matters which don't fall into gray areas oftentimes elicit answers that are unsatisfactory. And it is that area of oversight that would be eliminated. I think this is a risk. It doesn't pass my litmus test of maintaining fiscal responsibility, and it would be a mistake to shift the oversight down to staff, thereby increasing the possibility. Granted, I can't give you great examples of it. I can point to one that we had to deal with on the commission in my 7 years, but we had a grantee that was involved in activities that were inappropriate. The grant was denied, and the result of that was a great number of hours spent on trying to unravel a very difficult problem with a grantee. These are very isolated incidents, but in my view, oversight's critical. The commission is made up of people with a variety of experiences. We've had bankers on the commission. We have clients on the commission. They ask questions that need to be asked. And to reduce the amount of information given to the commission and increase the authority in staff only raises the risk level, in my view. And Sean, this is exactly the area that you were asking me about. There are others.
Well, thank you.
And if I could.
Thank you. Well, this is Sean Select. Let me say, I tend to agree with the concerns that have been expressed about this item. Leah, would you like to address the rationale for the proposed change?
So I think the idea is that we will move to codifying in writing many of the things that are currently being implemented based on one-off decisions and sticky issue meetings. so that you take less and less discretion out of the process, and therefore this falls more on the administrative side than the policy side. That was the rationale with those where policy decisions need to be made, they come to the commission. I fully appreciate the need for transparency, and I think there are many ways to make the even staff determinations public. But again, I don't know that we need to I don't know that we need to debate it. Certainly the rationale is about policy work versus administrative work. Right now, because we have so many things operating that are not contained just purely in the four corners of the guidelines and the rules, I don't think we have a transparent process, whether we're bringing things to the commission or not. The goal would be to have all of the decision rules in writing and for staff to implement them. And then I think, again, it's a more of an administrative process. That being said, you know, I certainly have the feedback here that there's not wide support for this particular proposal, and that's fine.
Can I just offer another construct for you to think about, which is with regard to these determinations, it seems you're suggesting that some of them staff will make the final decision. They then wouldn't come to the commission, and there's no current BOT role. And so if policy versus administrative may be an important construct to keep in mind, but fiduciary responsibility is an equally important concept to keep in mind. And some body or bodies, depending on the nature of the decision, ought to be reviewing, even if only in a cursory way, decisions that are being made by staff.
Right, and I think you get to it in number 4, and I think this is actually a place where a change is needed. So those decisions are being made on primary purpose, qualified expenditures, legal services, and then you, based on the amount of money you have available and the other sort of quantitative inputs, you get to the actual allocations per program. So this has a proposed commission role none. This is one of the errors, that this proposed commission role is the same. So the ultimate review of the proposed program level allocation would still be approved by the commission. And then this, as a new feature, would go to the board as an informational item. So I think this is probably, and I apologize for getting this out to all of you only today, but we've had a lot going on and just finished this basically in the last day or so. And so there's some errors in the document. But I think that's where you get to this point of who's actually looking at the awards that are being made to each program. And that still would be the commission, and then as a new area for review, the board under number 4.
So the word none should be stricken there.
It should say same, yes.
The only difference there is
Yeah, it goes to the board.
Yeah, so really, you get the final list with the amounts in it, and so that's the fiduciary part, yeah, and so this board. So I think that-
Which you would expect to have, but that's an important thing, yeah.
But it goes to the board as an informational item?
Right, and so we discussed internally whether it should go to the board for approval versus as an informational item. I was trying to, again, keep that distinction in mind between policy and administrative. The policy would be the board really weighing in. I think the rules perhaps need to be revisited, and certainly weighing in on the guidelines. That's all policy that ultimately ends up informing that the application of the definition of primary purpose, qualified expenditures, what are legal services. And so that's where I erred on the board making sort of approval types of decisions, as opposed to once the policy's been established and it's then implemented and you run a calculation to determine what each program's award is going to be. I saw that as a bit more administrative and therefore not needing to be approved by the board, but informational to the board. Again,
So it's all, I guess the phrase that's been used is formula driven. It's all formula driven?
the amounts, what, but
Well, even well, maybe formula-driven is not the right word to, when it comes to primary purpose and legal services, the ones under 3, the idea is that staff can simply read what the policies are, as I knock over my mic, can simply look at the language and then apply the language. And we're confident that they will, in 95% of the cases I heard, apply it correctly. And that's all that needs to be done.
Well, there's other alternatives here. So I mean,
I was about to suggest another one.
yeah, well, because I think staff can give an example. I know there are questions about what is a legal service. We have a very narrow definition of our rules, which I don't believe we've been applying because it's too narrow, and frankly, but it is in our rules. And so I know that there's been a lot of work done by staff and the commission, I think, to really kind of understand how do we reflect modern legal practice, which is more interdisciplinary, given the statute and the rule. Not all of that, or much of it, as I can
Has
tell,
joined the
is
conference.
reflected in the guidelines. So, but it needs to be, right? So then you have something written down that says, here is our understanding of what is a legal service. So then when staff is making that decision, they're working with something that's documented, that's public, that's available, and that's transparent, not exercising much discretion because it's written down
Has
what
left the
decision
conference.
rules are. When they have a question, it would still go to the commission under this construct, but not to the board. And so you may feel that when there are questions that cannot be resolved, that they ultimately need to go to the board on an individual grant award determination.
Okay, so the board has approved the policy in clear and pristine language that is very easily applied. I'm just wondering if maybe the legislature offers a model. I wouldn't say that ordinarily, but maybe in this area it does. There's something called the consent calendar, where a matter has been at least tentatively approved, but any member can take it off the consent calendar if they find a reason to object or they have questions. And I don't know how that would work into the language here so that it wouldn't be staff making a final determination. It's staff making something above a preliminary determination, a determination of some sort, subject to a review by the commission.
Sorry. My understanding is the commission will make that review once the dollar amounts are attached to.
And that would await the dollar amount.
They would await the dollar amount, and then that's when they would get the list. The commission would get the list to approve the programs. That's my understanding of
Is
what
that
we just
correct?
said.
Yeah.
That's how it works?
I thought you were asking, well, that's what the recommendation is. I thought you were asking about the recommendation in row 4 that this be presented only as an informational item to the board, not an action item.
No, I was speaking to
okay.
3, but actually.
Okay.
And to the staff making the final determination, suggesting that the determination not be final, but it's a determination subject to review, but at the discretion of the commission. But the commission would have to act.
Yeah.
It wouldn't
Yeah,
routinely go
Yeah.
to the commission for approval.
That's what I sort of understood the description of the present practice to be, and that's what I was advocating for when I said it really ought to go through the commission, rather than just leaving it to staff. But yeah, a consent calendar idea is exactly what I presume goes on.
So it wouldn't be routinely submitted to the commission, but the commission could routinely jerk it off the consent calendar, or whatever we call this. Does that make sense? Maybe.
Yeah, well, so the what wouldn't go routinely to the commission, I think, is a little confused. So in row 4, you have the determination of the program level allocation. That's the award that each program would get based on a review of primary purpose, qualified expenditures, the definition of legal services, and then the amount of funding that's available on a per county basis. And that would go to the commission. There's an error in this row where it says none. It should say same. So the commission would receive that and would have to approve it. So that, I think, is not recommended for a change. So maybe this is another one where we would benefit by coming back at the next meeting with
Okay.
some more clarity around what the current process is and how this would be different. But the commission ultimately would approve each individual program award, which encompasses primary purpose, qualified expenditure, legal services, the application of the formula, and then that information would go to the board as an information item, not for approval under this scenario.
And this is Selena for the benefit of those on the phone. I think it would benefit from some clarity, mostly as regards like the timeline issue, because I know that the report to the Judicial Council for Equal Access Fund grants includes amounts as well, but I think it's because their meeting, and Bonnie would know, is significantly after the Board of Trustees meeting, and so it's also on the consent agenda, but it does include line budget items. But I believe it's because it's afterward.
So do that.
Just a point of clarification. So when it comes to the commission for approval with the money and all the other decisions made, if a commissioner has a question about primary purpose, they could raise it at that point.
Yeah.
Okay.
Yeah. Oh, yeah.
And they have at that point all the information regarding staff decisions concerning primary purpose or qualified expenditures or whatever, so that they could pull it off the consent calendar if they needed to.
And that's how it could be structured, yeah.
Yeah. So then you don't really actually, seems like you have to have two meetings on the same, instead of having to go through the step one of the qualified expenditures, blah, 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 and the final, what amount they're going to get, just have it all rolled into one list that you vote off of.
Okay, so the last component under that broad number 3 is the eligibility conference. Can you, Dwan, just explain briefly when we hold those? There's no change recommended here. Okay.
Sure. So after staff does the first pass of the IOLTA and EF applications and bring forth substantive issues to the eligibility and budget review committee, at that time, the committee determines whether they need additional information from programs and to call forth an eligibility review conference with the grantee or the applicant, I'm sorry. So, and usually during those conferences, there are 2 commission members and 1 or 2 staff involved that meets with the applicant.
And about how many of those do we do each funding cycle?
I would say anywhere between 2 and 5 a year.
Okay.
This past cycle, we did 3. And I think we had scheduled originally 6 or 7, and some additional information came through, and so the 6 or 7 shrank to 3.
I'd like to add a little color to that comment. When the eligibility conferences occur, oftentimes the members of the commission's committee on eligibility are from different fields. And when client members, and I've done these conferences with client members of the commission, those client members ask much different questions than do the lawyers or judges that are on the commission, or the academics and others that form the commission. So in my experience, it's extremely informative, and it helps staff to focus on issues that they might not otherwise consider. Staff attends those meetings.
So the staff prepares the memo and provides background information, but the conferences are really driven by the commission, and they take a lead in questioning the applicants.
And these conferences are held when the staff has some doubts about eligibility, or when the applicant?
When the staff has raised what are, I think, referred to here as gray areas or novelty questions.
Okay, and that's all generated by staff. The applicant can't request an eligibility conference.
There is an appeal process, but that...
No, that's how it works.
Now, there's an appeal process that always goes to the commission, but
Okay,
staff has identified the problem children, brings them to the commission.
So there's a close question of some sort that has to be resolved. Okay. Okay.
This is quite granular from time to time.
Yeah, the issues vary. Some instances, it's a primary purpose issue. Sometimes it's a grantee that's had a perpetual late submission issue. So it really varies.
Okay. So we'll go on.
We were expecting a guest speaker, and I guess we'll have to keep that window open. But were there those on the phone or those present in the room who, for scheduling purposes or other reasons, wanted to make a presentation at this point?
Well, they're gonna do that 2:30.
Yeah, we'd prefer to push all that to 2:30. We'll press on.
All right. So number 5, review of program submitted budgets. So as I understand it, after the program has been approved for funding, then
Because of how the statute is written, we can't determine the funding amount at the front end of the application, so we have to determine eligibility, and that recommendation goes to the commission the commission for a vote. Once the commission has voted on eligibility, we have a list of eligible programs. Then we take that and run the allocation, and that takes us about a week or two to do. Once we have the allocation, we release to the programs that amount so that they can then carve out a budget based on the amount.
so this particular functional area is reviewing the budget that then the program has submitted. And right now, the commission approves budgeting of the allocation, which sometimes appears to get elevated to a conference, I guess.
Yeah, in some instances, there are substantive issues with the budget as well. They're less frequent than at the eligibility determination, but they do surface. And in some instances, those issues do elevate to an eligibility conference, and that's determined by the Eligibility and Budget Review Committee.
So the change here is that only those budgets that get elevated would be reviewed by the commission. It's similar to number 3 above.
But this is an area where I have a disagreement. It seems to me that those who are accustomed to reading budgets, who come from different areas, especially grant-making areas, will have a different perspective on the financial statements submitted by the grantees or the grant applicants than will staff. And the familiarity staff has with those budgets from year to year will tend to cause their eyes to glaze over, whereas some of the bankers on the commission are going to look at budgets and suggest that there are questionable entries, or there might be. And oftentimes what happens is those questions lead to the gray areas. The gray areas then result in further granular work by the commission on whether or not there is a budgetary issue. So I'd be cautious about making this change for oversight purposes.
I think we have.
Indeed. Welcome, Mr. Fuhr. Nice to have you here. We're respectful of your time. I appreciate your being here. We have some folks on the phone, and this is being webcast.
Turn his mic on for him.
How about that? Is that better? Okay.
Yes.
So, hi, I'm Mike Fuhr. I know many of you. I come here today as the City Attorney of Los Angeles, but that's really only a part of what brings me here. Many of you know that 32 years ago, I began my legal services career as the Executive Director of BetCedec Legal Services, which is, as you know, one of the most effective free legal services programs anywhere. And in that role, I had a very close working relationship with the Legal Services Trust Fund. In those days, Judy Garlow, whom all of us miss, was an extraordinary leader of a program that wasn't just helpful to BetCedec, it was fundamental to our capacity to represent the poorest people in our city, not only because of the raw dollars that trust fund funding provided to our organization, but also because of the fact that other sources of funding, like Federal Legal Services Corporation funding, were restricted in ways that ELTA funding was not. And that led us to, as was the case with so many legal services programs, expand representation in essential ways. I have another experience that I think has some relevance to why we're convened today, and that is eventually I became the chair of the Judiciary Committee of the California State Assembly. And in that role, had an opportunity to work with the State Bar on many different levels, I was a strong supporter of the opt-out approach that was taken, I think, in 2009, which enabled a significant amount of money to be funneled through IOLTA and directly to programs that desperately needed to provide for indigent clients. So with that experience in mind, I want to speak as I would if I were the chair of the committee overseeing judiciary even now. When someone came before our committee with a bill, especially one whose fundamental premises I wanted to dig into, I would ask, what's the problem we're trying to solve with this legislation? It's an approach that I think we'd all do well to bring to so many issues in our society. What is the problem? And I'm here today because I understand that if not the very existence of the Trust Fund Commission, certainly its role is in some jeopardy. And I want to urge that this commission here ask, what is the problem we're trying to solve by calling into question the continued existence and efficacy of the commissioners themselves? I will say from my personal experience, the commission always had insights and took actions that were not just important, but sometimes essential to the delivery of free legal services. It was past my time as Vet Cetics director, but very much in the bullseye of my time in the state legislature when I think it was in 2009, the bar's staff in the teeth of the recession, a recession all of us felt it had very grim implications for all of us, certainly in Sacramento. The bar staff, I believe, sought, in a way that I understand, to limit the funds that would be disseminated to legal services providers on the premise that funding was going to get increasingly scarce given the economic realities in the state. Unless I'm mistaken, the commissioners said just the opposite. They said, here is a moment in the history of the state when if we don't devote funding to free legal services programs, we are going to further entrench the poorest people in our state in poverty, and we are going to relegate people to losing their houses and their health care, who otherwise might remain housed and might remain with the ability to go to see a doctor. I take that example seriously as an instance where I think all of us can note the independent breadth of expertise that commissioners have typically reflected on legal services issues has benefited all of us. So I didn't want to spend a lot of time today. I wanted to be here to make that point from a perspective that is at least fairly unique, having been both a legal services program director and active in Sacramento in direct contact frequently with the state bar over a plethora of issues, and now as the chief lawyer for the second largest city in the country. I'm happy to take a question or two, and otherwise I just wanted to be sure that this voice was heard at a moment when I think we ought to be refocusing our attention on issues where in fact there is a serious problem that needs to be solved. I'm not sure that the commission's existence is one of those. Any questions or comments? Otherwise,
My name's Debbie Manning, and I worked for the legislature. I retired from there after 34 years, so I do remember your time there. I just want to thank you for taking the time to come and speak to us, because I know you are a busy person. I know how that works, and we appreciate your comments. Just to assure you that the commission's not going anywhere. So what we're really working on right now, is the governance issue between the commission and the board of trustees, which hasn't been a very effective one for some time, but we're really trying to make it so that we're more of a unit working together. And I think that we've sort of come to the conclusion that we can be a much stronger bar and provide more services for the people of the state of California who do need services if we're working together as a team and have one voice, kind of thing. So just to ease your mind, they're not going anywhere, okay?
Yeah, no, fair enough. And I want to say, this is not my first time as city attorney speaking on legal services issues. The last time, it was in the teeth of the discussion about, I'll reframe the question, what are the fundamental responsibilities of the state bar? And from my standpoint, as I said then, one of the most fundamental responsibilities of any lawyer is assuring that our justice system is fair and provides access to those in greatest need. And as we continue to evaluate in the face of, litigation that's pending and other issues, what is core to the mission of the bar, and therefore what is core to the way the bar is governed. I would say it's essential that we identify the most effective means to oversee the implementation of a fair and just legal services system. And if we're talking about making more seamless the relationship between the governors and the commissioners, fine, as long as the independent expertise based on real-world experience of the commissioners is sufficiently brought to bear in decision-making and not subordinated to other less important concerns. Thank you for the opportunity to be here.
Any questions?
We're back on our agenda at item 6.
Okay.
Did we finish with 5?
I don't.
I thought we were done with it. Any other questions about 5?
All right. Okay, so now we're on to the monitoring visits. I'm sure this will inspire discussion. So staff currently conducts monitoring site visits about 30 per year to ensure compliance with the funding requirements and to provide technical assistance. We've had a number of comments throughout this process about potential changes to the site visit process and the timeline, and I think those are all ones that we, the commission, and staff should consider, but just assuming the status quo process, this is it. And the commission is requested to attend by staff currently if staff have concerns, or for, I guess the commission attends for educational purposes. Could you elaborate a bit more on the commission's role in site visits?
So staff will sometimes flag when we would like a commission to accompany us because a program will have an issue that we need kind of a second pair of eyes to review and to help us interview with the staff at the program. In other instances, commission members are just interested in learning more about the programs and will attend.
So when staff request that a commission member attends, how frequently does that happen? What percentage of the applications does that happen for?
When staff specifically requests that's on a more rare kind of occasion, I would say every year it might happen once or once every other year. I would say that commission members attend because they want to learn more about the programs. That's what happens more often. And the commission members here can speak to that as well.
I'd be glad to speak to it. And one of the things that I noticed from the matrix is this appears to have a seriatim kind of thing, that things happen in this order, but in fact they don't. Site visits can occur at anywhere along this process, and oftentimes when the site visits occur, commission members ask questions which raise questions that are in item number 3. And so you will see that these cycle back, and I hope that this is understood by those looking at the matrix that it isn't seriatim. But I've gone on these site visits and I frequently raise issues, for example, of what are legal services, because there's a holistic approach taken by the grant recipient as to what's required in order to fully serve their clients. And those responses are evaluated differently by commission members than they are by staff. Because as a lawyer, you think in certain terms as to what's required of a lawyer depending upon the question presented by the client and the particular civil matter that is at issue, whereas staff persons aren't necessarily lawyers and their questioning is quite different. So I found it extremely helpful, but more importantly than helping staff focus on this particular applicant, these site visits educate commissioners and make them much more able to conduct their business as commissioners. And to discourage that, it seems to me, is a big mistake. We're trying to make commissioners much more knowledgeable about this process, and it helps.
I'm frankly at a loss about what this has to do with his review process. It has nothing to do with state bar governance. What is the reason, what was the problem, why we have to be discussing the relationship between the commission and staff on site visits. I don't understand the problem, or why there'd be a prohibition, at least that's how I read this, from having commissioners go on these staff visits.
The matrix is simply an attempt to delineate the key functions that are being performed either by staff, the commission, the board, or any combination of those. So site visits, it's certainly one of the functions, and you see the next one in row 7, the commission would approve the guidelines that are used in order to sort of effectuate the site visit review. So it's simply part of the functional analysis. This really aligns with changes that the board implemented with respect to law school accreditation, very different, but members of the Committee of Bar Examiners were going on site visits associated with the accreditation of California California accredited law schools, and there's a lot of discussion about just purely professionalizing the site visit process. So this aligns with that. In addition, unlike on the Committee of Bar Examiners side, my understanding is that commission participation in these site visits is sporadic, it's not consistent. And so then you don't have sort of the consistent, so let's say the commission member that happens to go on a particular visit brings a tremendous amount of unique and particular experience in a certain area. That approach, if that particular commissioner doesn't attend all the site visits, does not lend itself to a consistent and standardized site visit process for all grantees. So that's another part of the rationale. And I have, received like an anonymous comment from staff that I would not say which staff it was from, but that the fact that commission members themselves have affiliations with legal aid organizations does have an effect. I think about it during monitoring time, whether or not I would take a position against a program that has someone on the commission is something that I take into account. And so I do think in light of all of those kinds of considerations, that's simply why you see the recommendation written as it is. And again, my understanding is that commission members are not going on every single site visit now.
No, they're not, and I'm not sure that that's particularly necessary. I don't. This seems to me to be a fairly unwarranted micromanaging of the functions that we're doing. I don't understand why saying no. You have a site visits. If a commissioner wants to see one to find out what's actually happening out there, not every single one to find out what's happening, or if it is a grantee that there's been issues they want to understand, or as often happens, they want to hear about what some innovative programs are that are going on out there. I just don't see what the point is having this body spend its time micromanaging not state bar trustee issues, and I understand the reason we're talking about that, but the relationship between the commission and staff on episodic visits out there, and to say we're going to adopt a rule saying you can't do it when there's not a problem, I just don't get that.
Is it a cost issue?
No, I don't think it's a cost issue, but I get your frustration. I mean, it could be a cost issue over time if every single commission member wanted to go on every single site visit, right? Right. But I think it goes to one of the governance principles about being able to, the state bar, being able to appropriately sort of manage the allocation of its staff and other resources. It does speak to that. But to your point, Judge Seligman, if the board isn't going to decide that, or if state bar management isn't going to make this kind of decision, then who is? When you say it's micromanaging the commission because you believe this should be left up to the discretion of the commission, if it's micromanagement by who of what, then the alternative is to just let the commission make that decision for itself.
Yes, exactly. It is micromanaging the commission, just in the same way. If you are on an entity that makes decisions, you want to have the ability to go anywhere, frankly. The state bar, you want to be able to visit the LA office if you're a member of the Board of Trustees and go, and you don't need anyone's permission to do that. You are a trustee of the state bar. You are a member of the legislature, you decide you're going to tour the border. you're a member of the commission, you want to go visit a legal services entity. That's part of any sort of like to say, we're going to adopt the rule that says the only time the commission members can do anything is when they meet in San Francisco or at one of their board members, and they're not entitled to educate themselves. That's basically what this rule says. And I don't see any purpose for it. There's no problem that's being solved except to hamstring the commission in their activities and say to every single commission member, we don't care if you're interested, you are not allowed, and that's what this says, you are not allowed to go on a site visit.
And I just want to make one different point, which is it may happen only once a year or twice a year or whatever, but if staff really feels the need to have a commissioner attend a site visit because of whatever issues or problems a grantee presents, then I think it's a fiduciary issue about making sure that they have the ability to request that. And the way I read this, maybe I read it wrong, is that that couldn't happen because now staff will do all the visits all by themselves.
Yeah, and I'd like to chime in too, because in my 2 years, I've gone on 4 site visits. And to correct number 8, when you say the monitoring findings, that the current commission role is none, that's not true. In 3 of the 4, and you guys can attest to 2 of them, I made suggested changes to the findings, additions, things that I thought were important that weren't originally in the draft letter. And in all of those occasions, that was incorporated in the final letter. And I don't see as commissioners how we can approve the findings without having experience of actually being involved in a site visit.
It's an oversight issue, but if you pivot on the point, there's a relevance. The pivot ought to be that the board and the commission need to work as more of an integrated whole. Pivoting on it would mean that board members, in order to make informed decision, should go on a site visit once a year. Then it would make sense. Otherwise, I agree with you, it's micromanaging. Let's go to 7 on that note.
Silence.
7 is the guidelines, development of the guidelines for the monitoring visit. Staff drafts, commission approves, no changes are recommended. Any questions there? The monitoring visit findings, staff drafts, no current commission role. I think that's what you were taking issue with.
Can I respond to Jim? So Jim attended 2 of my site visits, and as a courtesy, I did send the letters to him. But as a practice, I don't think all staff have sent the letters to commission members that attend for feedback. That's just my individual practice. But that's not a policy that we have in our office, that the commission reviews the letter and provides feedback. But that's my personal practice, so.
Well, and I've gone with you and a couple other staff members, and that's always been the case with me. Maybe it's because I asked. I said, can I see what you're saying? And 90% I agree with, and the few modifications I've made has just been an additional observation. It hasn't been a disagreement.
You're proposing a change then to what is proposed, because the proposed commission role is none. It sounds like you're not advocating or you're not stating that there's a commission role. You're stating that commission members who attend site visits have the opportunity to weigh in on the site visit reports, and you would suggest perhaps that be institutionalized.
I'm proposing 2 things. One is I disagree completely with 6, that it ought to stay the same, that the commission should be able to go along on site visits. And I'm challenging 8 as not being accurate, at least in the 3 site visits that I participated in.
Are you saying that the site visit reports go to the full commission, or the findings and recommendations letters that are sent to the programs go to the full commission?
No, they didn't go to the full that I know of.
They would only go to the commission member who attended that site visit.
Right, and I requested it, and everybody cooperated with me, so, but I guess that's not standard practice.
Maybe it isn't, but it might be.
I think it should. Especially important for client commissioners because, as Rich has observed, they oftentimes come in with a completely different set of questions than the attorney commissioners.
Okay, should we move on to number 9?
Right.
All right, establishing data reporting requirements. This takes us to some of the issues addressed by the reboot committee. So maybe you can talk us through, Rocio and Duan, because I've asked questions about how the reporting requirements are actually, how and where they're codified, who approves what. We have here that currently the commission role is inconsistent, and all of this across the board is an attempt to make it a little more structured, but maybe you can describe the current process.
Here. Oh, there we go. Oh, there we go.
So, Juan can correct me if I'm wrong, but I don't believe any of the reporting requirements in terms of data collection are codified. And I think that in terms of, and I can speak more about the specific reports we have now, or what we either call reports or evaluations. There's not currently a consistent name for what we do require. The different processes and how long they've been around, including the ones that we've spoken about in previous meetings, such as the case summary report, the main economic benefits report, our new impact litigation advocacy work report, and then your specific discretionary grant report. So those are all of the ones that we spoke about in the very first meeting that I presented on, and that Corey touched on earlier today as part of the reboot conversation. So I don't believe that any of those are actually codified, and the data within them is either, but we have now required them of all QLSPs, at least the discretionary grant evaluations. If you receive one, you're required to submit one. The other ones are required of all QLSPs, and support centers are required, in addition to discretionary grant evaluations, to only submit the new impact litigation and advocacy work report.
So I think that the recommendation here, first of all, it's not really written here, but I do think we need to write down and have in one place what the data reporting requirements are, and for which types of grant recipients. And then the idea is that staff could implement on their own technical changes, and this gets back to the issue we sort of grappled with our first functional area, kind of what's technical, what's substantive. But staff could implement technical changes, but they need to be implemented in a way that was written down and then kind of clearly modified in existing lists. That non-technical changes would go to the commission for approval, and that non-technical changes would ultimately go to the board for approval. So that is a difference. Currently, none of this is going to the board. And as I have had these discussions with staff, it's not clear that all of it has gone through the commission. It's sort of been an organic process. So this would be an attempt to put some structure around it.
Can you give an example of what is technical and what is non-technical? Because I'm not sure what would count. I mean, if we were talking specifically about reboot, you know, the main benefits are likely to change regularly. And every year, probably, there's going to be some kind of refinement. Maybe not. Maybe we'll get it perfectly this time, but I'm guessing there may be some changes. I'm assuming that's probably something that we consider to be technical. So, but maybe I'm wrong about that. So what would be technical and what would be substantive? Since, yeah, I guess eliminating a whole area maybe would be substantive, or that sounds reasonable,
or adding a new area. So some of the, we've had a number of discussions at these meetings about whether or not we're fully capturing all of the work that the programs perform, and I think that's a future topic for the reboot committee, perhaps. We've had some conversations about how underreporting may be impacting the analysis of the clients who are being served and our continued interest in whether or not we are serving demographically representative population. So that kind of macro large issue on reporting, I believe, is one that should be considered by the board. So that's certainly a substantive. Main benefits, I don't have clearly in my head right now whether or not that would be or wouldn't be. I know that the main benefits report in its entirety is how we are articulating the value add of these services and using that report to advocate for more funding, both from the state and for all of the programs to use to advocate for more funding. So it's hard for me to see that as technical just sitting here, but I don't have full familiarity with it. I think there are a number of in-the-weeds technical changes on reporting, what should be reported in this category versus this one. We've identified this as a common error that programs are making. This is guidance on how you should be reporting X, Y, or Z. Those are the kinds of things that I see as technical, and I don't know if you want to jump in with anything you see.
We also update the evaluations every year, and I would say technicals and we're wordsmithing to kind of improve the question. That's not really a substantive change, it's just more of a clarification or improvement to the
But
question.
if we're talking about, for instance, collecting data regarding race and ethnicity, one of the issues was, I guess, how you determine households. Is that, I mean, I guess I'm having a hard time parsing that example. I mean, what exactly would you be asking the Board of Trustees to vote on? So for instance, maybe we could look backwards at reboots. The Board of Trustees were given a report of the fact that main benefits were going to be collected, but were not asked to, senior management didn't ask for a vote on that. And then they did vote on the calendar change. So is there something that they should have been actually asked to vote on? Then that could be articulated going forwards as something that needs an actual vote as opposed to a report.
Right. I personally believe, and I'm not speaking for the board, but I believe that the board should have weighed in on what the main benefits were and what was going to be the basis of this report that we're then putting forward on an annual or biannual basis to articulate the value add of these services on a statewide basis. I think yes, and in other areas, the board does weigh in on things of that significance. So I would say yes.
So the board vote would be to approve the impact report, or it would be that whether it is that the idea that the impact report as a document should be approved by the board? Because I mean, I feel like it would be very hard to articulate this, except to some extent leave it up to the discretion of bar management for some of these things to say, hey, I think that this needs a vote. I mean, I don't know how you exactly say, you know, this kind of data collection is substantive and this kind isn't. Or perhaps you make the report to the Board of Trustees and see how they respond, and they will say, oh, we think a vote is necessary. But I'm not seeing the dividing line.
I think it's really similar to the conversation we had regarding number one. And frankly, because now I can't even, if I've asked for it, I can't even look and see what all these reporting requirements are. It's a bit of a difficult conversation. I think that's step one. And I do think it's going to be a bit of a work in progress, just like the conversation we had regarding number one, to decide, you know, what makes sense. And so I can't give you a perfect answer now, but I know that right now, at a minimum, everything needs to be documented.
Sure.
And then there needs to be some clear decision rules, again, about who approves what kinds of changes. And we don't have that right now. So this is the proposal. The proposal is the defining line is technical versus not technical, understanding that that is, you know, that's sometimes an imperfect or unsatisfying kind of delineation.
I got a couple of questions. One is about the codification of the measurement. I mean, what do you call the handbook that we work so hard on? Defining the different categories and what information should go into that. I mean, isn't that a set of rules and procedures?
It is, but they're more, this goes back to like guidelines, considering that there is an entire page that is titled Guiding Principles in terms of how you should complete main economic benefits specifically. And there are some exceptions to understanding that organizations are different, all grantees. There are some even to main economic benefits. To give an example, that you should, if you're able to, only report on outcomes for closed cases. But if you're unable to, if you would lose outcomes achieved in the evaluation year for cases that remain open at the end of the year, you're allowed to report them. So that's one of those kind of inconsistencies.
Sure, but I'm saying there's been a lot of work put into that. It's been modified several times, and the question is, do you want the board to approve all of those details? Is that what they want to get involved with? And then other questions in terms of measuring impact. For example, the whole issue of household, which makes an important household size, which makes it important on total people impacted, say in income maintenance or in housing situations. But I was just talking to a legal aid provider here today, where their client is basically the child in terms of adoptions. And their client is counted the child. So it doesn't make sense, especially if you're taking two siblings and trying to get them adopted by the same parents. How are you going to count household in that situation, right? Because you're either going to double count or you're going to undercount. And some states like Massachusetts, when they're looking at their economic impact, when they have an issue of child support, what they do is they take the amount of money that they're getting that year, they take that with the assumption, and there's some arguments in the literature that is there, that the average divorce and custody hearing, the child is 8, and they assume that the support's going to go out to age 21, and then they multiply that, and they say, look at our impact. Well, do you want the board to say, well, we want to make those kind of measurement assumptions? I mean, I've always advised against it because I think those are too problematic. But there are states out there who do that.
I know we have to move on. I would say that one of the, sort of an example of how I would see this working is that the board would say, we want to do everything that we can to collect information. We want to capture information that reflects the full scope of the work being performed, regardless of the service type. And we want to collect information to the extent possible that captures the demographics of who we're serving. Then that would be the charge to the commission and staff. Then the commission and staff work that up. How can we do it? What are all the issues? What are the problems? How onerous is this going to be to report, et cetera, et cetera? And then that would ultimately go back to the board. We understand the policy that you established. Here's the work that we've done, and this is our recommendation on how this can be accomplished or not. And that kind of thing would ultimately, in my mind, be approved by the board. But that's how it would work. I do know we need to move on, and we certainly come back to this at the next meeting.
I have just one question that I think hopefully can be fleshed out by the next meeting, is if the Board of Trustees is going to approve a recommendation, can they modify it and therefore have a new change? So for example, if the Trust Fund Commission says we've considered, we don't want to ask questions about immigration status because we think many programs don't ask that for a particular reason, that comes before the Board of Trustees, and the Commission saying we don't recommend we collect this, but Board of Trustees said, oh, we'd love to have this info, we're going to start asking that. So just a little bit around clarity around if the recommendation is not before them, can they create a new change?
My understanding is the board does have that ability generally. With respect to resolutions that come before them, can they take action outside the four corners of a resolution? Yeah.
All right, on that note, we need to be respectful of the time of folks who asked to have their comments reserved. Now is your time. We'll resume on January 9th with this matrix, and perhaps we'll get some definition where we need it. But I would like to ask those who have reserved time, please come forward.
I think this is on already? Yes, excellent. Hi, everybody. Tila Chalmers, Alameda County Bar Association in Oakland. I'm actually going to wear my Bar Association hat today because I also run a 1,500 member bar association in my county. And as part of that work, I go to a lot of nerdy bar association conferences nationally about best practices in bar associations. Those conferences are attended by large and small bars, mandatory bars, voluntary bars. And they all share many of the issues you all have been discussing here. What does board oversight mean? And where is the line between board oversight and actually doing the work? How do you balance the work of volunteer entities, which you depend on, and yet you don't want them to subsume the work of the board? What is true transparency? How much do we want to know, and when do we want to know it, and how can we learn it? As an example, nonprofit board members are actually individually liable if their organizations do not pay payroll taxes, which is terrifying, right? I know those of you on boards are like, wait, right? So the solution to that fear is not, of course, for the board members to write the check, right? It's to come up with some mechanism that reassures the board member. So in our case, we provide the board periodically with documentary proof that we paid payroll taxes. Another option would be to ask the auditor to report to the board in the annual report to include that fact. So there are a lot of ways to make those things work. Sean mentioned the need for greater collaboration between the Board of Trustees and the Commission, and I think that's awesome. I've heard a lot of great ideas here about that. Those might include making the liaison program stronger, avoiding the scheduling conflicts that have made that challenging, maybe have more regular reports from both the Commission and the Office of Access and Inclusion to the board, even every meeting. To get the board more information on bank grants, because I've heard a lot of questions and feelings about that, and I think, I don't know how all that unfolded, but I think more information is a great thing. I want to mention one thing about size. There was a real trend in bar associations about 6 or 8 years ago to make everything small. There was a book called The Race to Relevance that sort of encapsulated that theory, and it was that no board should be bigger than 5 or at the most 7 people. In my experience in bar associations, including mine, we followed that trend, and then we walked back from that trend because of a couple things. One, it's really hard to have enough people to do the work if you only have 7 people. Secondly, the real problem you're trying to address is one you should actually address. So a lot of people said the reason to do that was because people, when you have a big board, or a big entity, people get disengaged and they don't pay attention and they're on their devices, and and the point was that we realized is what we really have to do is address that problem. We have to sit down with that person and say, you seem disengaged. Do you not want to be on this board? Because that's okay. But, we need people who are engaged in the conversation. Also, the quorum issue, interestingly enough, actually works the other way. When you have just 7 people and 4 people are sick, you're out of luck, right? You don't have a quorum. If you have 20 people and 4 people are sick, you're still fine. Those people are still sick, but there was a question raised about whether there should be volunteer bodies making decisions in a mandatory bar, and that happens all the time and is really quite common. In fact, the Virginia bar, which was cited, Leah cited in her PowerPoint, has a number of volunteer decision-making bodies, including one that decides whether or not lawyer referral services, which are regulated by mandatory bars, would have to be disciplined or discontinued. There are other bars that actually use volunteer bodies to discipline lawyers. Obviously, we have state bar judges that do that, but it's an interesting model. So I've heard it said here a bunch that it's unclear what's happening now is unclear, that there's lack of clarity about who decides what. And I guess that's not what I'm hearing. I think there's some people who are really clear. I actually think Dwan sounds really clear to me about what the rules are, and some members of the Trust Fund Commission sound pretty clear. Others may be less clear. So making it clear is a good thing, but I don't know that that brings us to a sort of a crisis that we have to take big steps in order to attain that clarity. And finally, my comment on the matrix is that it appears to me that it concentrates authority not in the Board of Trustees, which is how this whole thing was presented originally, that there needs to be more authority for the board. It concentrates it, and it doesn't concentrate it in the board, which is understandable because there's not very many of them and there's just so much they can do. But it concentrates more authority in State Bar staff. And just the examples that you all have gotten through today have sort of exemplified that. And I'm quite sure that by that, this does not mean line staff, right? That's just not how organizations work. It means management staff of the bar who are very hardworking, very smart people, but they don't have experience in this area. And this is a professional area that many of the people in this room and on the commission have spent their entire professional careers working in. And I think moving to fewer people with less experience making decisions is exactly the wrong direction for the bar, the State Bar of California. We want to be moving towards more accountability, more transparency, and more professionalism. That's all I have to say.
Thank you. Is there anyone else who wants to come on up?
I would like to make a few, hi, Kim Kruckle, Child Care Law Center. Hello, everybody. A few disconnected remarks. One, first of all, thank you all for your time. I know that this is a big endeavor. The Child Care Law Center where I work is one of the, I'm going to address for a moment the bank grant. We were getting calls many years ago from people all over the state whose towns were denying them a permit to operate a little daycare in their community. So we were helping people figure out how to navigate their local zoning laws and permit laws. And we really didn't have the staff or the travel money or anything to do that, but it was how people got to work in these little communities all across the state. So when the bank grant money came, it was like a godsend, right? Oh my gosh, here's this this windfall that's speaking exactly to what we're trying to do: community redevelopment, helping communities get to work, run small businesses, et cetera. So just to iterate that the Trust Fund Commission, whom I never met at the time, I only heard about through the application process, spent years, months and years figuring out the procedures by which we could apply for and be eligible for those grants, how we would report on them, how we would prove we were doing a good job. And I just heard about all the trust fund activities sort of secondhand, Trust Fund Commission activities secondhand, as an applicant and subsequently a recipient. So I just wanted to offer a little, process, shed a little light on the process from the view of an ED. And of course, it's we've changed laws in more than 20 towns, helped more than 600 daycares open as a result of that across the state. So it's hopefully just the beginning. So that was one point I wanted to make. Also, I want to try not to talk too long, but to me, as a person who has a board of ambassadors for the work that we do, the larger the group of people who are ambassadors for your cause, the better, because we are trying to raise money and awareness and end problems together. So the more people that are involved, the more we're getting closer to our goal. And it really isn't about just what's efficient. We do not live in an efficient system. I mean, we're California. We decide our state budget by going to the ballot. Things are messy here. Everything's messy. Everybody gets to play. Everybody gets to decide. So this just sounds like it's all in keeping, just from my one other observation. I guess lastly, I have come to most meetings, And it is starting to feel a little, with all due respect for everybody's time, it is starting to feel a little like, okay, well, first it was claimed that we weren't serving Hispanics across the state. And then that was shown to be sort of not, the data wasn't accurate. And then there were claims or suggestions that maybe we should make the grant making more streamlined and more efficient and do a better job evaluating. And we showed how we were pretty happy with the streamlining of the grants, and we actually were doing a pretty good job evaluating our programs and our impacts. And now today, there's like this long discussion about something that's really just between, it seems like it's just between the staff.
Has
Like,
joined
who's
the
doing what?
conference.
So I guess I'm starting to feel really confused about, or really starting to agree even more with things people were saying 2 months ago, which is, what is the problem here that we're trying to address? So I'm just going to echo that. I really don't mean to be disrespectful, because I know that everybody has put a lot of time and for some people it's been a learning experience, but I would like to invite anybody who wants to come visit our program and see what we really do, see the impact evaluations that we do in my office, see the reporting and data collection that we do, meet the staff, meet the clients. And my final statement is just on the data reporting thing, whether or not that's codified, whether or not we're doing that. I mean, it is in the statute what you have to do to be eligible. And we actually have to report on that every single year. How many qualified legal services, I'm a support center, so how many qualified legal support programs did we serve? Where were they across the state? How do I assure their quality? We answer, those are the dating reporting requirements. They're actually right in the eligibility law in the statute, and we report on them when we renew our application every year. We can always, look for more or different data to show our impacts, but that's our eligibility, and that's what we're reporting on. So I'll stop there. Thank you again for your time. I know it's hard.
Thank you, Kim. Bonnie?
Hi, I'm Bonnie Huff. I'm the project manager for the contract between the State Bar and the Judicial Council for the Equal Access Fund. And I've been doing that for 19 years now. So I probably have the most kind of institutional history and have been attending nearly every commission meeting since that time. So I think that this is, and I want to just make sure that everybody realizes that $26 million that is distributed by the Legal Services Trust Fund Commission comes through the Judicial Council. So the Judicial Council has a fiduciary oversight role in this area. And as a result, it appoints 7 voting members to the commission and 3 non-voting members, the judicial members. And so I will say that I am deeply appreciative that in those 19 years there has not been any scandal. There has not been misuse of funds. There hasn't been anything that makes anybody worried or concerned, because I think that the commission and the staff have done a remarkably good job. And the fiduciary oversight, I think, is very strong, and I really appreciate that. There are a couple of other things that I think haven't necessarily been brought up. Well, one thing that I think is important is that the contract does refer to a huge stack of regulatory documents, and to make sure when the Judicial Council, which was at that time the Administrative Office of the Courts, took this on, we looked really carefully at how the funds were administered and whether there was appropriate oversight. And there was a determination that there was, and that we should follow how IOLTA funds were reviewed and considered. And the one change that was, one of the changes that was specifically made, one had to do with audits, but the other had to do with the 3-year, we asked for a 3-year review rather than a 4-year review, which is what IOLTA had done. So if the commission, or if this group wants to change that, it would be really important that you let me know, because I'm actually, there are accounting people that have strong feelings about this, that we would need to bring into that discussion and make sure that that was comfortable. And obviously it would go back to, I don't know that that would have to go back to the Judicial Council policy-making board, but we would need to take a look at that. Anything in terms of changing the number of members on the commission would have to go back to the Judicial Council as a policy-making determination, because they did vote on that and they made certain determinations when the fund was established. So I will say also, I think it's great that staff is working on writing guidelines. I think one of the challenges is there was staff who was at the commission for like 20 years, and they had this stuff, you know, back of their head, knew it. So I think there were certain things that never got written down because they'd been doing it for so long. And as new staff has come on, I think that, you know, they're having to really work through those issues. And I think they're also having to consider, as Leah pointed out, sort of the new way that, you know, legal services are being provided, and maybe people are doing things electronically. And I mean, there's just a whole lot of things. And I think they've really done a fabulous job of thinking it through. And I think it's great to have that guidance. And I think it's incredibly important for the grantees to have as much clarity as possible. That said, I don't think there's any way that you're going to be able to resolve every single issue in guidelines. And I mean, I think you've identified that by saying there will be things that need to be brought to the commission. But I assure you, I have participated in a number of those sticky issue meetings. And I really care about this stuff, but I find those meetings painful because of the detail and the minutia of the kinds of issues that have to be worked through. And if I find this painful, I just caution that there is a level of detail that, you know, but they are also really important. Like, what do you do? What does this mean? And every year there are always things. I mean, God, this is a creative community that's always coming up with, well, could we do this, or could we do that, or whatever? I mean, it's just not going to be something, and those decisions have to be made in a fairly timely fashion, right? And so any kind of guideline process that would presumably need a lot of input from the board, or you know, from the community, and you know, in a policy-making role, just be mindful that I don't think we can imagine every scenario that could come up. That said, as I say, I think it's great that guidelines are being drafted, but just with that caution that cannot, I don't think that can all be done. And then the other thing that I think is important to realize, and it hasn't, this commission in the last few years hasn't been as engaged, but one of the things that I know is on your agenda for the next meeting is to consider, or is on the agenda for later that will probably go to the next meeting, is the idea of increasing funds. And the commission has had in the past a full committee that worked on increasing the interest rates.
Has left the conference.
And that was extraordinarily helpful. And it was composed of very savvy, very high-level attorneys, right, who could go to the banks and go, come on, you can do another 0.5% or whatever, which is like $1 million, you know. It's way more than we can get through many, many other sources. It's incredibly important. And so that hasn't been as active in recent years, but I just want to say that this commission works on it spends an enormous amount of time, and I've always been impressed by the thoughtfulness, the creativity, the care that this commission shows. And you know, with the partnership grants, equal access, the eligibility, now the bank grants, but the IOLTA, and just looking at how do you increase funds has been really, I just would hate to see that piece lost as well, because I don't think there's anybody else out there who can really work on increasing interest rates. So that would be my, I think that's it. So at any rate, I just want to, again, mostly caution that if you're thinking about major changes, or I mean, even potentially technical changes in reporting requirements and things like that, we should just be in communication so that we're aligned with the contract and the vision of making sure that the funds are well spent. And thank you very much for everybody's efforts. I know this is a huge amount of work. Yes.
Yeah, Bonnie, since you've attended more of these commission meetings than any of the commissioners have, do you think the commission would be as effective if it was shrunk down to the size of 7?
No, I do not. I think that as I say, the committee meetings, which are often 7 people or, that have been really effective. But no, I really think it needs that kind of diversity of perspectives. I think that's really added to the strength of the decision making. And I will say, I mean, I am not aware of staff a number or assist in staffing a number of committees at the Judicial Council, and I'm not aware of any committee that we have that is as small as that. And every time we make a grant, it has always gone through subject matter committees that have given a lot of thought, because the Judicial Council, just like the Board of Trustees, just doesn't have an enormous amount of time to do this. And I guess one other thing is on evaluation. My staff has been really involved in evaluation through the years, and we are, for example, really working on the partnership grant evaluations now and trying to sort of streamline them a bit for both for staff and for the program, so that we can get results faster and that sort of thing. I think that would be considered technical, but that would be the kind of discussion and decision. And we have worked really closely. We started the evaluation process back when the funds were established, because we had a report due to the legislature in 2004. And so every program, we developed a whole toolkit of evaluation strategies so that every program could report and talk about what they were doing. We have worked in partnership for those many years. But we've also worked in partnership with LAC as part of that, because it was really important that, that we got the data, that it was useful and helpful for everyone, so that we could actually, the whole point of evaluation is not only to show that people are doing, what are we accomplishing, and that it's something that's actually relevant for people, because there's a lot of times we get the data and we can't necessarily interpret it because we don't know enough about the subject matter or other issues. So it's an important partnership. Any other questions? Thank you.
Just because Bonnie raised
Sure.
the IOLTA, I did want to say we do have 3, I believe it's 3 staff that are dedicated to working on the IOLTA funding issues, including auditing the banks and what they're doing, and pursuant to, I believe, the efforts of our staff as well as the improving economy. 2017, the IOLTA revenue was $7 million. 2019 projected to be $35.5 million. One of the things that staff has identified as being really impactful was we, as the state bar, put out an RFP for our general banking services this year, and we indicated that their IOLTA rate would be taken into account in evaluating. And so that impacted the 4 largest banks in California. So we have done quite a bit on increasing IOLTA revenue.
And I appreciate that. And my only point is that sometimes having somebody with a lot of juice who is on the commission who can have those discussions can also be helpful. But I recognize and appreciate those efforts. It's incredibly important. Thank you.
Fred Baylard is one of our commissioners. He has a term that hasn't ended, and he's a former banker working on those matters.
Thank you.
Good afternoon. My name is Jen Braun. I am the president and CEO of the Alliance for Children's Rights. We provide free legal services and advocate for kids who've experienced abuse and neglect. And like all of the other legal services
Has left the
providers
conference.
here today, we are typically stretching really limited resources to help the most folks that we can who are in real need.
Has left the conference.
And in the interest of time, I would just encourage this group to keep our eyes on the prize and really realize that in resolving what may be efforts to clarify or smooth tensions between sort of internal tensions with staff, with the commission, with the board, we shouldn't lose sight of what we're all trying to accomplish. And I was really glad to hear this meeting start out with those common goals, because, unintended consequences are words I hear all too often. I really don't like those words. And I think that as long as we kind of keep front and center getting those services to the folks who need them, it will help us maybe sort of keep this discussion productive and limited to what it really needs to be. And I would encourage everybody to remember that if we would like to avoid things like charges of bias or favoritism, to the extent that we have a formulaic system, that helps protect the bar. That helps protect all of us. So there are good things like that that we have in hand that we should be careful to protect. So that's the main comment. The only other comment I wanted to make was that most, if not all of us, have a really strong internal audit procedure that does every year report on internal controls. I think it is really important to make sure that those internal controls are in place, to make sure that funds are treated properly, that there is, nothing wrong that takes place. And to the extent that those things that we already have can be useful, I would encourage this group to, take advantage of them if that can happen. Thank you.
Thanks, Jen. Mr. Lash? Yes, fire away.
Hi, I'm David Lash. I run the Global Pro Bono program at O'Melveny and Myers, and as I explained last time, I previously was the executive director at a major IOLTA grant recipient, and I served on the Trust Fund Commission, and I served as chair of the Trust Fund Commission. So I'm coming from a variety of perspectives. And I just want to offer my major perspective, which is that
Has left the conference.
Which is that my understanding is that this group was formed and charged with examining a recommendation that the Trust Fund Commission be eliminated. And what it led to has been 4 days of really robust discussion, and I want to say thank you for that, because I think that what has come out of that robust discussion is a public airing and a public affirmation of the important work and the effective work that the Legal Service Trust Fund Commission does and has been doing for many years. The testimony, the public comment has been virtually unanimous in the value and effectiveness of this body and its important, critical role in the delivery of legal services to the poor throughout the state of California. So I want to say thank you, because I think this has been a very valuable exercise in publicly